Good morning, and I'm pleased to have you here. We've got 4 members, I believe, of the committee present, and our rules speak of a quorum of 4. So I'm not sure who else may be coming later, but we'll go ahead and begin the meeting at this time. I think for the benefit, first of all, we have a court reporter. I'd like to have the court reporter introduce himself to us. And I don't know if you got a mic over there, number 1. You can pull number 1 mic and just speak to it.
Yes, sir. My name is Will Robertson with American Court Reporting.
All right. Thank you, Mr.
Pleasure
Robertson. To be here. To introduce who else is on the dais up here, we have at the far end our legislative counsel, Wayne Allen, and then we have next to that Jill Travis, who is also in the Legislative Council office. We want to introduce people for Mr. Robinson so he knows who's up here when we talk. He can have that proper done. I'll start with you, Representative Comer. Introduce yourself. Yes, sir.
All right.
Number 19.
Christian Coomer, C-O-O-M-E-R.
And I have next to me Jordan Reed is my assistant. And then we have next at number 23, I believe.
Mary Margaret Oliver.
And further down,
John Meadows.
All right. I think the first thing we'll do, we have some rules that have been prepared, and I believe they were submitted to all the members of the committee. If you will pull up your rules, take a look at it. Do we have any changes to be made to the proposed rules? If there are no changes, I'll take a motion as to the adoption of the Special Study Committee rules.
Second.
Moved and seconded. Any discussion? If not, we'll call the main question of approval of the rules. All in favor signify by saying aye.
Mr. Chairman, I'm sorry.
Yes, sir.
Didn't jump in there quite in time.
Sorry, go ahead.
I had one question about the Rule 6.
Pull your mic around if you would for us. There you go.
Am I on there?
You all right? Yes, sir.
Hello?
I'm not getting you.
I'll just talk louder. Rule 6, which says that all fact witnesses shall be subpoenaed and shall testify under oath. I didn't know if the committee, I can't remember from our last discussion, if we had talked about inviting witnesses.
We did.
As opposed to.
Good point. And we are inviting witnesses, and the fact is that these will be fact witnesses that are voluntarily appearing today, and there is not a need to have a subpoena provided to them. I think we need to modify that to the point that just recognizes that the fact witnesses may be invited to appear and testify under oath. Other witnesses who may be necessary in the opinion of the committee to appear and will not do so voluntarily, a subpoena may be issued for their appearance. Would that be acceptable?
Yes, sir. Yes, sir.
So with that change in rule number 6, do we have anything else to change? Would that change be acceptable to the motion and the second? All right. All in favor of the proposed rules as amended by Mr. Comer, signify by saying aye.
Aye.
Opposed, like sign. That motion carries. I wanted to begin the meeting of this committee just by having each of the committee members, if they wish, to provide a statement for the benefit of the public. And I think I will begin as chairman, if I might. And I want to first talk about the background of this committee. I think we have been involved with this process for a while, have sat by quietly and silently while there's been some rhetoric going on as to this being a political motivated committee, trying to destroy the Judicial Qualification Commission of our state. And I want to put that issue to rest if I can. I think what we'll have is information brought out by these hearings that will be available to the public, and I think allowing the public itself to be the judge of the facts, determine whether there's a need or not to have some modifications of the Judicial Qualification Commission. We're not trying to destroy the commission. The problem we have, I think part of it is under the current constitutional language, there is really just a very strict status of how the commission is set up, and really no opportunity to make any changes in the status of that and how they conduct their business, because it has been set up as a truly autonomous body, and no one, including, frankly, the Supreme Court of Georgia, has say-so about how they do their business, conduct the business. In fact, there's been, I think, an adversarial approach between the JQC and the Supreme Court over some issues about advisory opinions, which I thought was kind of strange, because the Supreme Court of our state is certainly the highest determining body as to what is recognized or not recognized as being appropriate judicial conduct, and we have a canon of judicial ethics that makes that determination, which is adopted by the Supreme Court. I think one of the most difficult tasks that we ask of individuals in our society is really to serve as a judge. Judges have to weigh the evidence, make tough decisions, while all the time following the law. And many times, if not all the time, the people who come before them may not be satisfied with what is done as far as a decision by that judge, but we expect the judge to make those decisions, and we demand of them very high standards in their conduct and how they conduct their business. We don't allow judges to break the law, and we expect them to follow the judicial canons of ethics as they provide their work and services to the public. And because of these high standards to which we hold them, their reputation and careers are always at stake. And when they fail, they must be held accountable for their conduct. And for this reason, the people of Georgia created the Judicial Qualifications Commission, known as the JQC, back in the early 1970s. We expect judges to be fair, impartial, and give due process to all those who come before them for business. However, the same is true for any judge brought before the JQC. He or she is entitled to fairness, impartiality, and due process. Information has come to at least me, to my attention, as well as I think others in recent times, that has occurred a failure of the JQC to always meet the standards expected of them in performing their duties. There has also been a concern that members of the JQC as a whole are the same persons who review the investigations, determine if charges are appropriate to be brought against a judge, and then they serve as the same person as the trier of the fact and the judge of that case. This has brought about, I think, a concern because you're having the effect of the JQC serving as the prosecutor, the jury, and the judge. Certainly this raises issues of fairness, impartiality, and due process. And I can think of no other system of discipline set up this way, not only in the state, but nationally. I have practiced law a long time, certainly long enough to remember before we had a JQC. And over the years, I have practiced before judges I felt should be removed. The JQC performs an important service to our state. And neither this legislature or the governor or this committee is pursuing a scheme to abolish the JQC. Nor are our actions to be considered as coddling judges or protecting those who fail in their duties as a judge. However, just as we expect judges to be fair, impartial, and give due process to those who come before them, judges who are investigated by the JQC are entitled to nothing less than these same standards. When our judicial system fails in its protection of a single citizen, it fails for all of us. So why are we having these hearings? I submit the primary purpose is to examine where our current system has failed, if it has failed, and then why did it fail, and what changes should be made to be sure standards of fairness, impartiality, and due process do not fail again. Yes, we have put forth a constitutional amendment for the voters of our state to consider during the upcoming general election, and we have passed a bill in contemplation of the passage of this amendment. I personally find the stringent and flexible provisions of our current constitutional provision to be failing in the face of what we're trying to make as improvements to the JQC. And I say that in a sense because the current provisions of our Constitution do not allow for anyone to have say-so, whether it be the Supreme Court or this legislature or the governor, as far as how things may be modified if it becomes necessary. And yes, I believe there may be some shortcomings in House Bill 808 which need to be addressed. And if the Constitutional Amendment passes, we can expect that there may be some changes made in the proposed legislation under which the JQC will operate. As a part of our report, this committee can help formulate what those changes may be. And I would ask if any other committee members have a desire to address the committee or the public before we begin taking information. Ms. Oliver.
Thank you, Mr. Chairman. My first job out of law school was to practice in rural Georgia with legal services, where I appeared before the justices of the peace, who were paid based on a fee system. And the highest paid judge in the United States of America was the JP in DeKalb County, who was handling hundreds of dispossessory actions based on fees. It was Governor Nathan Deal that eliminated, as he was chair of the Judiciary Committee in the Senate, who eliminated the old bad JP system and instituted the magistrate court for small claims. And about that time, a little bit after, I became a magistrate judge in DeKalb County. So I certainly, in my long practice, have seen significant improvements, and the JQC has been part of those improvements. As a litigation lawyer, as litigation lawyers, we sometimes institute, but we certainly manage and participate in conflict. But our ethical duty, our professional and ethical duty, in my opinion, is to resolve conflict and to create solutions and not enhance conflicts. So I'm very grateful, based on several years of conversations with judges and their concerns about how the JQC was operating procedurally, not with necessarily results, but procedurally, to have an opportunity to have a professional conversation about some opportunities for solutions where we can move forward in a positive way to enhance the quality of this very, very important task. Thank you, Mr. Chairman.
Thank you, Ms. Oliver. Mr. Bell, do you have any comments you'd like to make? You might pull your mic around if you would, please, sir.
I'd like to remind everybody in here that I am not a lawyer.
We have Mr. Meadows on because of his extensive wisdom.
I'm the rules chairman, but I have served as a municipal judge, 11 years of that madness, but mostly the people that will be doing the talking here will be the lawyers. I'll try to sit over here and shut up and learn something. Thank you.
Thank you, Mr. Meadows. We got your number 20, or that was better?
All right, I'll use that one. Mr. Chairman, thank you for the work you're doing here. I think most Georgians probably have never heard of the JQC, the Judicial Qualifications Commission, and probably don't know what it does, and they don't realize what a very important role it plays in our society. We understand that courts are an important aspect to any free society. They give us a place of access for redress of grievances against the government and against others in our society. They act as both a glue for society and kind of a cushion to help us to be able to resolve dispute without resorting to violence and without resorting to upheaval of our society. So having a JQC that oversees the conduct of judges on the bench is an essential element to maintaining the integrity of the system, of the judicial system. And having a functioning JQC is is a co-equal importance to our society as having a functioning judiciary. So I want to point out that, you know, bad actors often seek to blame others for their behavior whenever their bad actions become known to the public. And that's not new. That's been happening since Adam blamed Eve when the Lord asked him why he took the bad fruit. So it's not new. What I would point out is that it seems that some of the folks who have allowed this issue to come to light by their own behavior would seek to defray responsibility to others. They would seek to try to blame others, and in fact say that we are organized for some kind of a political process, which we are not. We're not here for. We're only here. The impetus of this committee is to find out what has gone wrong with the JQC, and to try to make remedy for that and make sure that it is able to continue performing its very important societal function. So thank you for your work, Mr. Chairman.
Thank you, Mr. Comer. Let me say, I'm not sure how long this hearing today will take place. I will suggest that probably about sometime around 12:30 we may take a brief break for a bite of lunch. We're going to probably order for the persons appearing today before us, and for those up here at the diocese, a Chick-fil-A sandwich. So be prepared for that. We'll take a short lunch break at that time. I think at this time we have two individuals who have previously served as directors of the JQC. That's Mr. Jeff Davis and Judge Ronnie Joe Lane. And I'm going to call on them individually, probably with the one the furthest back service, which would be Jeff Davis. If you'd like to come forward, Mr. Davis, and speak to us, we'll have you sit at the table in front of us. And I'll ask Mr. Robinson, once you get seated, to administer the oath for you.
Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
I do.
First of all, let me thank you on behalf of myself and the committee in agreeing and volunteering to come today to speak to us about your prior experience with the JQC. I've known Mr. Davis for many years. I think we can talk about the time when you were serving as JQC. I was very supportive of what you were trying to do. We went through some tough financial times, of course, as all the agencies did in the state. And I recall trying to do what I could to pull together resources and others to assist the JQC to be sure you were able to continue that work. And Mr. Davis now serves as director of the State Bar of Georgia and doing a fine job for all the members of the bar of the state, and we appreciate your service in that capacity. I'd ask if you wish to make an opening statement to the committee. Mr. Davis, please do so at this time.
Thank you, Mr. Chairman.
There, I got it on now. Excuse me.
Okay, make sure. I had the privilege and the honor to serve as the director of the Judicial Qualifications Commission beginning in 2010. Before that time, I was like Representative Oliver. I practiced law all over the state. I live in Madison, Georgia with my family, and my practice was out in rural Georgia. When I started my practice, I was in the city of Atlanta and worked with Attorney Bruce Harvey handling criminal cases. I've handled federal cases. I've done just about everything. I've appeared before about every type of judge you could appear before. So when the position came up to be director of the Judicial Qualifications Commission, I was practicing law in a small town, handling criminal matters, domestic matters, before a fantastic judiciary out in the Okmulgee Circuit. And it appealed to me, the position, and I applied for it. And because I believe, like you do and all the members of this committee, that the most important thing that we have in our nation is a rule of law. And if we cannot have confidence in our judiciary, if we cannot have confidence in the decisions that are being made, then we're on the edge of tyranny. And so I had done, in my early career in the 1990s, I had worked previously at the State Bar of Georgia before now serving as executive director I was a prosecutor of disciplinary cases involving lawyer misconduct. And so I thought that my wealth of experience as a practicing attorney around the state in rural and in urban Georgia, as well as my experience having prosecuted lawyer misconduct cases, I thought that uniquely qualified me for the position, so I applied. And I was honored and privileged to receive the position in 2010. I first served with Chairman Ben Easterlin, who was a former state bar president. I served with him for just a few months, and then he rotated off the commission. And then I served with what I think is, who I think is one of the finest judges in Georgia, Judge John Allen from the Chattahoochee Circuit. Not only is he a former Vietnam fighter pilot, but he is a war hero, but he is also a civil rights hero. And he was an outstanding chair of the commission during the time that I served. His vice chair was Robert Ingram, who was a former president of the State Bar of Georgia from Marietta. I served with him as well as vice chair and then as chair. And those are the three commissioners that I served with and chairs, and also a fantastic group of other lawyers and lay people and judges on this 7-member commission. When I inherited the commission, and I use that term intentionally because I view the work of the commission as a public trust, and when I inherited the commission from the former director, the budget was in crisis. The budget had been cut, and the first order of business that I had was to come down here and to meet with you, Mr. Chairman, and others on the Senate side to see if we could get some more money. We were the most underfunded commission in the country and still are the most underfunded commission in the country. And I met with you, and it was during a budget crisis. And as you said earlier in your comments, we worked together to get through that period of time. We had to come up with some novel ideas. We couldn't hire any more people. I came to you and asked if we could hire a disciplinary counsel, and you had some great ideas about how we could bridge the gap while we were going through a crisis in Georgia. And we worked together, and I'm proud of the work that we did during that time, because even though we were lean, we were still effective. True. And I thought we handled the situations that we had with judges as well as we could under the circumstances. And frankly, it was an unprecedented time of judicial resignations, judicial investigations, and it was unlike anything we had ever seen in Georgia. It was unfortunately like a cancer that was growing on the judicial system. And the guardian of that was the JQC. And so we had to, with our 7 volunteers, the commissioners who were volunteering their time, 2 citizen members, 3 lawyers, and 2 judges, we worked together tirelessly. We were on the phone all the time. We were meeting constantly, dealing with these issues. And as you look back on it, it was a difficult time. It was a time of challenge for the commission. We were having to be nimble. We were having to make decisions on the fly. We were having to confront an avalanche of cases. Our complaints doubled in that period of time, and our staff did not. And we worked hard to resolve cases with the ultimate goal was always to ensure public confidence in the judicial system. And if a corrupt judge, if a judge who was engaged in misconduct was brought before the commission, our goal was to address the situation as soon as possible. And as Chairman Willard said in his earlier comments, there were some judges who needed to be removed. There were some judges who had committed such egregious acts of misconduct that those cases had to be resolved quickly, expeditiously, again to protect the public trust. And so I'm here today voluntarily. You asked me to come. I care very much about this commission. I care very much about the role of judicial disciplinary enforcement. And I'm here today to offer the experiences that I had from 2010 to 2014. And as we move forward and try to improve on the process, to talk about some things that worked and some things that didn't work, some things that need improvement, and as we are facing the opportunity of a new commission, we don't know what the voters will do in November. And if the voters do approve this constitutional amendment, then there is an opportunity for us to try to create something that not only that we can be proud of, because we're stakeholders in this room, but ultimately we need to make sure that the public is served by this process. So I'm here today to answer any questions that you have. There is a shroud of confidentiality, as you know, over the commission. There are some things that I can talk about in specific. There are some things that I may not be able to talk about as specifically, but we'll try to address the questions that you have of me. So thank you for the privilege of being with you today, and I'm at your disposal. Thank you, Mr. Chairman.
Thank you, too, Ms. Davis. Let me begin, if I might. I want to ask, on the last topic you were talking about, which is the confidentiality, in the past, has there been ability of the JQC, while you were director, to have information on cases that have become closed disseminated to other organizations such as the GBI or anyone else maybe doing investigation work? Has that been a practice of the past of the JQC, and can you address
Yes.
that?
There have been instances where we have received subpoenas from either the GBI or the FBI or the U.S. Attorney's Office. We have always been responsive. When I came on in 2010, Judge Allen was the chair, and we took the position that if law enforcement was interested in one of the cases that came public, that we would cooperate fully within the extent of our rules. Our rules do allow the commission, if a subpoena is issued, or if the commission frankly believes that it's appropriate to share information with a law enforcement agency, that we would do that. And there were times where we did share information with the GBI or the FBI. There were also occasions when we would be working hand in hand. There was a situation involving a judge up, and this is public, and you can assume if I talk about a judge, it's a public matter. But there was a situation up in North Georgia where we were investigating a magistrate judge, a chief magistrate in Murray County. That particular magistrate, there were accusations that he had actually facilitated the planting of drugs on one of our witnesses who had actually come to us confidentially to reveal very egregious conduct where this particular person had been propositioned by the judge in an inappropriate way. The GBI, we were working with Director Keenan and others on that in tandem, because our investigation actually was going on at the same time. They were looking at the allegations of the planting of drugs, and thereafter the U.S. Attorney's Office got involved in that case with the FBI. That particular judge was indicted, was tried. I actually was called as a witness in that case. It was before a U.S. District Judge in Rome. He was convicted and sentenced. So that's a situation where we are actually working in tandem with law enforcement. But sometimes after a case became public and there were allegations in the case that a particular law enforcement agency might be interested in, they would contact us, and that we would provide the necessary documents that we believed were appropriate.
You used the term when the case became public. What do you mean by became public? Please, sir.
There are several ways a case can become public. One is by nature of the actual judge who's under investigation, who may go out and make public statements, which has happened before a case is actually filed, before a case is where a consent order is worked out between the judge and it's filed in the Supreme Court. Under our rules, the triggering of where a case goes from confidential to public, that happens when an actual case is filed, either a consent order with the commission and the judge related to admissions by the judge or an agreement by the judge to a particular disposition. That is filed in the Supreme Court. At that point, the case is public. There are other situations where we have filed actual formal charges against a judge and we have a hearing. When the formal charges are filed in the Supreme Court, at that point the case becomes public. But again, when I was director, that case is in litigation. That case is pending. So it is not a matter in which we have press conferences. It is not a matter in which we discuss things with the press. The matter has been filed with the court, and there is a preparation for a hearing with the judge. So in the sense that it's public, the citizens know that a case is proceeding against a judge, but it doesn't mean that we open up our files, much like a prosecutor who files a criminal case against a defendant. Yep. While the case is pending, the file is not actually disclosed to the public, because that would be a violation of the judge's right to due process to try the case in the media or give the information to the press while the case was pending.
It comes to mind there are at least two cases I'm going to be questioning individuals about, and these judges are going to be appearing before this committee. They've at least indicated they will voluntarily appear. They have also indicated they're wanting their files to be turned over by the JQC to this committee for our review as a part of what went on with their particular cases under review by the JQC. Do you know of any reason why, if a judge asks for a file to be released, that it should not be released by the JQC?
I'm not aware of any situation when I was at the commission if a judge waived their right to confidentiality, and it's the judge's right. You know, a judge can waive that right at any point in the proceeding. Why a judge could not get a copy of a closed file, certainly. I can understand why a case was proceeding that a judge may not be able to get the file because there's still an investigation going on, and there may be investigative reasons for not disclosing that at the time. But if a case is over, we have situations all the time where judges who are before the JNC, the Judicial Nominating Commission, they're seeking another judicial office, and they file a waiver with the commission to release all of their files to the JNC. And I actually, when I was director, I appeared before the JNC if there was a matter involving a judge who was being considered for another position. Most of the time, 99% of the time, those cases did not result in discipline. They were cases that judges revealed in their application to the JNC where they had had complaints filed against them that had been resolved in their favor. There had been a dismissal, but the file existed. And so I would come before the commission and basically confirm what the judge had said and have the files with me. So that's a situation also when a judge is applying for federal office. I've met with FBI agents who are doing background investigations on judges, and they also file a waiver. And in those instances, if the FBI needed access to the files and the judge had waived those, had waived that right to confidentiality, there was no reason we didn't provide those. So it's the judge's waiver, and it's his or her confidentiality.
I understand. That's what I would thought would be the case. And I raise this point because we've already received information, not directly but indirectly, that there will be a challenge made to our receiving any files from the JQC, even with this right of waiver being granted apparently by the judges. And in fact, I know the JQC has apparently already retained the services of an attorney for that purpose. And the information that's come to us is that retainer attorney is charging $550 an hour as a basis of challenging the opportunity of those judges to receive their files and for us to receive the files to review with the judge. So I'm a little dismayed about the already conduct taken by the JQC. I assume it was done by approval or vote of the members, but we'll find that out later. Anyway, that's something we'll have to, a bridge we're going to pass shortly. Okay. Speaking about the rules of the JQC, and this is one of the things that I guess has come to my review and concern, and that is, during the time that you've been a director, did the JQC always follow the procedure rules as to how a complaint would be processed and information provided to that judge of a potential pending claim? And by claim, I guess we call it a complaint. Do you know of any time where that was not being done with the guidance of what your rules provide to be done?
Not, Mr. Chairman. I mean, there is quite a bit of flexibility in the rules related to just as you talk about receipt of complaints. The actual rules provide for the commission to receive information. This is consistent with the ABA model rules of judicial disciplinary enforcement, which provides that the commission, a judicial disciplinary commission, should be able to accept matters which are confidential or which are not necessarily anonymous. There's a difference between anonymous and confidential. The people who have the most information about judicial misconduct are generally the people who are most reticent to bring that to the attention of the commission. If they had to put it in writing and sign a complaint, a written complaint, these are usually court personnel, clerks. Other judges, frankly, were some of our best tipsters in letting us know about information in their circuit involving judicial misconduct that they never would have to have written down on the complaint. So as it relates to receipt of the complaint, there was some flexibility. A lot of our complaints came in written form. Some of them came in oral form. If it was confidential, the commission would take what was very similar to a confidential informant analysis that you would see in a criminal context. We would verify the information. We would certainly not act on something we received in the mail that just was a letter with nothing on it. We would have to hear from somebody, and those folks would like their confidentiality to be protected. And what I would say to them, generally when we would get a call, is that, like in a confidential informant setting in a criminal case, I can tell you the commission will do everything to protect your confidentiality, but there may come a time in the process where, and I need to tell you this, there may come a time in the process where your confidentiality will need to be revealed. So that would be, of course, if there was an investigation, there was a hearing, and I would explain to them that we don't have many hearings and the likelihood of that happening is pretty remote. And I would want them to know that before they revealed the information to me. But your question about following our rules, we certainly tried. We endeavored to follow our rules scrupulously.
Well, let me read a part. This is under Rule 4, Paragraph B, and I'm going to try to paraphrase rather read the whole thing. Upon receiving a complaint or otherwise receiving information indicating that a judge may have been guilty of willful misconduct in office, et cetera, et cetera, et cetera, or that a judge is disabled, and let's say, read on down, the commission may make an inquiry of the judge for such written comments. Now, the question there is, once it reaches a stage that there is going to be past just the initial investigation, does the commission then give some written information notice to the judge that there is a potential complaint against you and ask for you, the judge, to make a response to that?
We do that when I was there, and in addition to that, we would often invite judges to come in to the commission by written invitation, to come and appear before the commission to discuss the matter.
Let's stop right there for the mayor.
Yeah.
If you ask a judge to come in, is the judge notified of what the purpose for their asking to be appearing before that commission given to them?
That was my practice when I was director. I notified the judges in writing or their counsel. A lot of judges had lawyers who were representing them. I would also often, probably more than half the time, talk to the judge about the expectations of the hearing, and frankly, not a hearing, the conversation, because I wanted to let the judge know that most of what we're doing is trying to discern information, and I would have conversations with the judge before the hearings, letting them know what we're going to cover. I would also send a letter notifying them and outlining, usually in kind of a bullet point fashion, please be prepared to discuss the incident involving Mr. Jones. And that sort of thing. But I would often talk to judges on the phone and really try to settle them down a little bit, to let them know
Yes,
this
sir.
was not, the purpose of this was not an inquisition, because frankly, some of the greatest work we did at the commission was when we got inside the room and judges came in and they
counseled
sat
with them.
down.
Yes,
And
sir.
we talked and we counseled and we made a real difference in the way that not only the judge perceived the commission, but that judge got to hear from his or her colleagues to say, well, Judge, you probably could have handled it this way. It would have been better. And everybody has a bad day, and it sounds like you had a bad day, and sometimes you just need to get up from the bench and go and cool off. Or to hear from a lawyer who, the beauty of the commission is all the stakeholders in the judicial process are represented around that table. So they get to hear from other lawyers who say, you know, Judge, that just didn't look right. If I'm a lawyer representing this particular person, I walk into this situation, I feel like I'm getting home cooked. And I know that wasn't your impression and your intention, but that's the perception. And then they hear from citizens who say, Judge, if I had seen this, this would have given me a lot of pause. And so the best work that we did as a commission was bringing people into the room and counseling with them and talking to them, and that was 90% of what we did.
But they always knew why they were being asked to come before the commission.
They were when I was there. They were.
Have you heard of instances where that has occurred since you left?
I have heard of an incident where that occurred after.
And what was that incident, if you
That
please
was
tell
the
us?
matter that I've read in the paper. I had nothing to do with the case, but it was the matter involving Judge Becker.
All right. And have you seen anything regarding her file as resulting from your being a director? That all occurred after you left the JQC, is that correct?
It did.
All right.
And I've not seen the letter that I understand there was a letter that she was given inviting her to come in, and I haven't seen that letter.
All right. Well, I have. We'll get to that later since you were not involved in it. Were you there during the time of an issue addressing Judge Scoggins, who is from a probate judge in Bartow County?
I was, and I will just say you stated in your place that he has waived the confidentiality.
I haven't got it in writing yet.
Okay.
Mr. Comer knows Judge Scoggins, and we're waiting to get those documents in place.
Okay.
I'll state in my place that he has said he is waiving it and he intends for us to review his file.
In fact,
Okay.
let me ask you this. As to Judge Scoggins, are you aware that he sought to come before the JQC over a period of time?
After I left.
After you left, okay.
The Scoggins matter started, I believe, in April of 2014. I left the commission around about July of that year. And the initial inquiry, and again, there's a difference, and I'm glad you pointed that out. There's a difference in inquiry and investigation. An inquiry is where we have received information, where we're just making what the word means. We're contacting the judge, and corresponding with the judge, either by telephone or by email, and I'm trying to find out what's going on. And at that stage, it's not an investigation. There's no docket filed. There's no formal file. It's just, we've received some information. We're making an inquiry. We're trying to determine whether this is something that we should look at further. And in his situation, I had started an inquiry based upon some information I had received.
From whom?
From Lester Tate, who at the time was a member of the commission but was not the chair of the commission.
What was the reason for his bringing that to your attention? What was his issue?
As best I can recall, he had gone to the probate court and had attempted to file a document or a pleading on behalf of a client in I think it's a traffic case of some sort. In rural areas, probate judges handle traffic matters. And so he had gone to file a pleading in the court, and based upon what he had told me, he had had some resistance by the clerk of court to the filing of the pleading, and she had made certain demands upon him that he didn't think were appropriate under the law. He was trying to file a waiver of arraignment and a not guilty plea at the time, which is standard practice around the state, and the clerk refused to take the filing and said that he had to waive his client's right to a jury trial at the time. And apparently there was a back and forth about that, and he brought it to my attention. And I don't know if it was during the initial conversation that Mr. Tate had with me, but he also, at some point along the way, mentioned that there was also some signage that was on or near the courtroom doors that indicated that certain members of the public were not permitted to be in the courtroom due to the capacity of the courtroom. And we had issued an opinion about public access, and we were trying to educate judges around the state about the need for public access, not only to records in the courthouse, but also to courtrooms. And this particular sign was, in Mr. Tate's estimation, was problematic. And I think we later determined that, in fact, it was problematic. And again, at that period of time, we weren't disciplining judges. We weren't investigating judges about open courtroom issues. We were doing this inquiry where we were calling them and saying, Judge, do you realize, because frankly, a lot of judges enter their courtrooms from a hallway and they never see the door, especially in urban settings. They go in a secured entrance and they actually never walk through the door that the public walks through. And there may be any number of reasons that a sign is on their door.
Like
maybe
a bailiff could have put it there.
A bailiff, sheriff's department. And we had that situation. So our comments and our approach to judges was to be educational, to say this is something you may have not known about, but understand the public perception. When they see a sign that says defendants only and they're lawyers, that's a problem. Because if I'm a member of the public, I read that and I say, well, I'm just here because I want to watch court today, but I guess I can't come in. Mm-hmm. So there was an issue related to an open court question, and I don't remember whether that came up at that time or not. And so the initial inquiry I made of the judge was the issue of the court clerk refusing to accept pleadings.
You talked to the judge?
I eventually talked to the judge. The first inquiry I made, I believe I emailed him. I can't remember how I contacted him. Again, it was a soft approach. I was just trying to say, there's this situation which has occurred, and I just kind of want to know what the matter is. And he emailed me back, and we had an exchange. We talked a little bit about his position on requiring a lawyer to file a waiver of a jury trial at the time they filed their waiver of arraignment. And frankly, you know, that's not the way we did it in Morgan County, and that's not the way I'd practiced law, and I thought it was kind of a novel approach, and I said, I just don't think that that's appropriate. I don't think that's legal. And so we went back and forth, and it was just a legal discussion. We had a very nice, very respectful interchange going back and forth about the matter. He described to me during that conversation, when he did later call me, because I do remember a phone call at some point where he advised me that that his clerk had told him about this altercation that had occurred with Mr. Tate. And again, I didn't investigate any of this to determine whether it was factual or not, but the perception was, and he had been told by his clerk that Mr. Tate had come into the office and had made demands upon the clerk. And the allegation, and I'll underscore that, the allegation was that he had apparently said something about the fact that he was on the JQC. And the judge, as I recall, during this period of time, was at a judicial training conference and wasn't actually in the office when it occurred. The judge called me and said, I'm very concerned about this. And I don't know, at some point in the back and forth with the judge, and again, I'll say the judge and I had very respectful conversations. Yes. You know, I never told him he was, you know, that he was under investigation. I was just making an inquiry of him to figure out what was going on. I believe I talked about the courtroom issue because I remember him telling me his courtroom was really small. And he had size constraints. He was trying to ask me for advice about how do you deal with that. And I said, well, the U.S. Supreme Court says you got to get a bigger courtroom. You know, if you've got courtroom problems, you got to find a bigger courtroom. And we often actually help judges with that. We had a lot of municipal judges who were confined to little, basically closets, trying to handle court issues, and they would actually ask the commission for a letter to help them with the mayor and council so they could find a bigger place to hold court. And again, we facilitated that. I talked to mayors. I talked to and said, folks, you can't have these cases, you know, in a small room. You've got to find another place. Again, all part of our efforts to increase public confidence in the judicial system, that people can get in and see court and they're not outside. So I didn't elevate the case.
Did you find he violated any of the canons of judicial ethics in his work?
Well, we, you know, technically, would the signage on the outside the courtroom could have violated a code of judicial conduct? Was it appropriate for us to look into that? Yes. That wasn't my goal. My goal was to get the sign off the door. Right. And I don't think at any point in that dialogue with the judge, I certainly never told him that we were opening a case against him, and we never did. And I was concerned about the matter which had occurred between a member of our commission at the time, Mr. Tate.
What was your concern?
Well, my concern was that this particular clerk had obviously had an experience with him, and he had purportedly used his status.
Did he say, in effect, I made a threat to cause a judicial qualification commission
That's what the judge told me. That's what the judge told me that happened.
Yes,
and I can't tell you whether that occurred or not.
All right.
But it wasn't the kind of case I would have investigated anyway. It was the kind of cases would have been ended at the inquiry stage. And so that was the end of it for me.
Did you see anything that was done by the judge in his conduct of this question about requiring a plea be entered at a point where there's a request for a remove the case or not to, because as I understand, the probate court, if there's going to be a jury trial, doesn't conduct jury trials.
That's
It has
correct.
to go then to either a state court or superior court, a trial court.
That's correct.
And I believe in this case, the question was, well, do you want a jury trial or do you not want a jury trial? If you don't want a jury trial, then waive it so we can go ahead and process this case. Was that in violation of the law? Anything you know?
No, I mean, and I certainly never suggested to him that it was. I thought the practice was unusual. I wasn't accustomed to what he was, and it was illegal. It was a legal question, and whether it was appropriate under the law was really a legal question, and that's what we were talking about going back and forth with the two of us. And you can have ethical issues when you are violating the law. I mean, Canon 2, the old Canon 2, when I was there, said that judges are required to comply with the law. That doesn't mean that every violation of the law is an ethical issue, but there are some violations of the law which are so well established and so inappropriate that they do rise to the level of a canon violation, where you, for instance, we had a judge in South Georgia who, when a probate judge, when people would appear before him and the trooper was there and the person who had been pulled over for speeding was there, and his announcement was, you know, ma'am, it's not this trooper's job to prove that you did it. It's your job to prove you didn't do it. Now, that is a legal issue. But that is so profoundly against established law that would rise to the level of an ethical issue, because it takes away the presumption of innocence, it burden shifts, and those are the types of things that are not debatable. And so there are some legal issues which, if a judge violates them, are also canon violations.
Yes, sir. So as I understand, you came to a conclusion with regards to the Scoggins matter that there was nothing there to further investigate or proceed with as far as before the JQC with a complaint.
That's correct. Judge Scoggins was very cooperative, and we had a very interesting conversation. I think the end of it was that he might, the county attorney got involved, the solicitor got involved, and we kind of shared legal theories back and forth about the issue, about the filing of pleading. And I think at the end of the day, we all realized it wasn't quite as clear as any of us believed it was. And I do remember the judge, or maybe it was the county attorney, suggesting that they even get an AG opinion, Attorney General opinion, about it. But I don't know what happened with it after that point. So I had nothing to do with it past that point, and that was the end of my involvement.
Did you inform Mr. Tate of this?
I don't know that I had a direct conversation with him about it, except to say, Mr. Tate would have known that there was no investigation because he gets the docket every month, and he would see the cases that have been, as the director, I made the preliminary decision to place matters before the commission and assign them a docket number. That's when it went from inquiry to investigation. I don't specifically remember a conversation with him. I think I probably followed back up and said I've had a conversation with the judge, and I think I recall Mr. Tate telling me that, you know, he had actually filed a request for jury trial, and the case was not even in the probate court anymore. I don't recall if I informed him about the issue involving the open court question. But I wasn't. There was no case. It never got docketed. It never appeared on our docket, and so to that extent, that's all I can remember about the conversation. It just really, the case just wasn't really that serious. And
Yes, sir.
so I was trying to deal with the situation, and frankly, I think one of my greatest gifts, and some of you may know I'm an ordained pastor, and I think one of my greatest gifts is to try to calm things down and to bring, to be the mediator in a situation. And I saw that situation had kind of gotten a little hotter than it needed to be. And so my goal was to try to deal with the issue that I did think was problematic, was the open court question.
Yes, sir.
Work with the judge, try to tamp it down a little bit, and we've done our job. And we can move on to something, frankly, that was more serious.
Thank you. And while you were there, as I understand, if Judge Scoggins wanted to come and appear before the JQC regarding this matter, did he ever make that request to you?
He would make that request of me, and there was never a time that a judge was denied the right to appear before the commission, even if there was not a docketed matter.
Yes, sir. Did Judge Scoggins make a request to you?
He did not make a request to me.
All right, sir. Are you familiar with the provisions of the current constitutional language as far as the JQC?
I am.
Is there any agency, other body that has any oversight, as you read the standards for which the JQC was created, by which someone can make adjustments to what they do and how they do their work?
I'm not sure.
Is that clear? Let me rephrase that because it didn't come out too good. Under the current language of the Constitution, does any other body or agency have any oversight as to the work and conduct of the JQC?
The Supreme Court, under the current Constitution, has oversight over the rules. The current Constitution provides that the Supreme Court shall adopt rules of implementation. Also, the Supreme Court has review over all matters involving a judge who is removed or resigns from judicial office. The Supreme Court has review over all of the decisions as it relates to findings of fact, conclusions of law, and any recommendations of discipline that are made by the Commission after a hearing. That matter goes before the Supreme Court. The court reviews the record. My understanding, it's a de novo review. They review the record and then issue their opinion on that. There is also a provision in our rules, I think Rule 22, I might be wrong about that, but it's on advisory opinions. Mm-hmm. The way that the current rule is crafted, the Supreme Court has the right to review all the opinions of the JQC, and they can ask the JQC after an opinion has been issued to revise, to change, or to rescind an opinion which has been issued, which is a little different than the advisory opinions for the State Bar of Georgia. Under the State Bar model, the bar goes through the process of writing the opinion, and then that opinion is actually provided to the members of the bar for comment and the public for comment. It then goes to the court, and the court actually issues and approves the opinion. Under the current rule that was created by the Supreme Court when they created the rules for the JQC, the way it works is the commission can issues the opinion, has the right to issue the opinion, and then after the opinion is issued, the court can ask the commission at that point to revise, amend, or rescind. Opinion 239, which we issued on open courtrooms, open records of the court. That matter is, of course, before the court now, and I've listened to your opening remarks. And again, those challenges which were made to that opinion, and I believe 239 and 240, were made by the Council of State Court Judges. And that happened again as I was leaving, after I left. It was right around the time that I left when those challenges were made, and I was not part of.
Right, but in fact, the Supreme Court did make a inquiry and a review of that particular rule. Is 239 the number?
It's 239. It's currently pending before the Supreme Court. They
Yes,
have
sir.
actually not issued an opinion. So under the current rules of the Commission, 239 still is a good opinion, because it has not been
Modified by the
it's
Supreme
not been
Court.
modified by the
As
court,
yet.
and I believe that's been pending before the court for a year.
Was it strange to you to find that became an adversarial issue with the Supreme Court and the JQC?
I would have
I guess
to
I'd
say
say
yes.
I'd say I would too, as a lawyer, that here is the Supreme Court of our state having to get into a really adversarial dispute with the JQC about the propriety of a rule adopted by the JQC.
Right. I mean, ultimately, I guess the tension in all of this is that while the Supreme Court is the ultimate arbiter and is the head of the judicial branch, the Commission is a constitutionally created independent body in the Constitution, in the judicial section of the Constitution, but the rules that were created by the court and approved by the court say that actually do empower the Commission to issue these opinions and give a lot of power to the Commission, frankly, to issue these opinions. And while I was there, we issued, excuse me, I think 3 or 4. And we were very, careful about the manner in which we went about issuing the opinions. And ultimately, there has to be an oversight.
Yeah. And I look at the Rule 22, and under paragraph D, it says the Supreme Court's determination of the propriety of particular conduct shall supersede any conflicting advisory opinion of the committee. And so I'm wondering, why would it become an adversarial issue between the JQC as to we have the sole right to make these opinions and you can't challenge what we did?
Well, I do agree with the the idea that the Commission has the right under the current rule to issue an opinion. But I do not agree with the proposition that they're not reviewable. Most of the opinions have been issued and have not been ever reviewed. But there needs to be a body, and it seems appropriate that it's the Supreme Court that reviews the opinions. Otherwise, there would be totally unchecked power on the Commission to issue any opinion they wanted to issue. And then it would have the force of law, because under the rules, an advisory opinion in a violation of a holding in an advisory opinion could be grounds for discipline.
Yes, sir. So we see the oversight that we have with the Supreme Court in areas. What about as to any misconduct by a member of the JQC? Is there anybody as a organization that has any oversight to bring them into discipline purposes?
Under the current Constitution, anyone appointed to the Commission has a constitutional 4-year term. There's nothing in the Constitution itself that has any removal provision, because it would be my position, and I'm just thinking out loud here as a lawyer, that if there were, under the current Constitution, if there were grounds for removal and the member would not voluntarily resign, then I believe your only recourse would be impeachment.
Yes, sir.
There's nothing, and now there is a provision in our rules where the Commission can vote by a majority in any matter to recuse a member. So there would be a way
Cause a member to be recused?
to cause a member to be
Okay.
recused. You could actually, if you had a situation where you believed a member should not be sitting on the commission could actually vote in every matter to recuse that commissioner. That would create, obviously, a lot of consternation
Yes,
and difficulty. But that would be a way that you could do it internally. But impeachment is the only way to actually remove someone.
All right, I'm going to allow other members. I've been occupying the time, and we can do it by, first of all, the minority leader, Ms. Oliver, and then we'll go by seniority.
I think I'm both senior and
22 or 23?
23.
23, okay.
I'm not sure I have the official minority leader title. At some point, I want us to have an in-depth discussion about confidentiality, and the chairman can tell me whether this is the right time or not. But you referred to two other different systems where matters are confidential up to a certain point and then public at a certain point. The State Bar's disciplinary process is that complaints are confidential until there's something like a probable cause determination by the State Bar, and then there's a disciplinary panel of lawyers that goes forward. And it becomes public after, I think,
A filing in the Supreme Court. It's actually beyond probable cause.
all of that process is confidential. All of those, I'll speak up. All of those matters that under the State Bar system for lawyer disciplinary matters are confidential until there's an official pleading. And then in relation to criminal matters, criminal investigation files are confidential until the case is resolved.
Correct.
I'm being overly simplistic here. Would you please compare those systems to what might be appropriate in your view about judicial qualification matters as we talk further in detail about what should or should not be confidential and what are the policy considerations in that? And Mr. Chairman, again, if you'd rather have this discussion another time,
I think it's a good question, and I do have experiences with both systems. The State Bar system, as you have aptly pointed out, everything is confidential up until a filing in the Supreme Court. Probable cause is not the determinative factor on confidentiality, because there are cases where the investigative panel of the State Disciplinary Board actually finds probable cause that there has been a violation of the rules of conduct, and a lawyer is actually held accountable, but it is on a private disposition, either a letter of admonition or a letter of caution sometimes, or an investigative panel reprimand where the actual lawyer appears before the investigative panel and is reprimanded for his or her conduct in a confidential manner. And those matters remain confidential at all times. And of course, it is the lawyer's confidentiality. And so, and there are times where a lawyer applying for to appear pro hac in another court has to reveal that information. But there are limited circumstances where that would be revealed. In our system, and I say our, the JQC system, the process is very similar. It's but we don't have the two panel system. And we also need to get to that discussion about investigative panel and hearing panel, because that's something that I have been concerned about and the Commission's been concerned about since I came aboard in 2010. And I had conversations with Chairman Willard, and I believe you, Representative Oliver, about back in 2010 about trying to get a constitutional amendment to go to a bifurcated process where we had an investigative panel that determined probable cause on the Commission, and we had a hearing panel that determined whether there was a violation. But the idea of our confidentiality is very much the same. Most of the discipline that occurs is confidential. It's in the manner of a letter of instruction or a letter of admonition, reprimand. And I think, again, that's some of the best work we do.
Is it good or bad for the public policy?
Well, I think that to the extent that what you're trying to do is change judicial conduct and behavior, I compare it to kind of a warning ticket on the highway of justice. There are just some infractions which are de minimis and which are nonetheless infractions where, frankly, a judge just had a bad day and committed a violation. Something slipped out of his or her mouth that he shouldn't or she shouldn't have said. And they have a history of many, many years of professionalism. But they still need a warning ticket. They still need to have discipline. So I do believe there's a place for confidential discipline because I think it slows judges down. And I think it causes them to remember when they receive a letter of admonition. And those letters would always involve some sort of instruction or some sort of admonition to adhere to the canons going forward, but in the future, this is how you may want to handle it better. And we hope that creates a memory. And in terms of public policy, I do believe there's a tension. I mean, I do believe that the public has a right to know when judges have been disciplined, but there are some very low-level disciplines that in the context of providing the discipline, if it were public, I don't believe that it would have the achieved result. And the achieved result is to modify behavior. Now, those confidential disciplines are records, and they can be used in the future. And so if a judge does not learn his or her lesson and repeats the conduct, then we have the warning ticket to go back to and say, Judge, we told you to slow down. You didn't slow down. In fact, you went faster. That's not what we meant. So those generally don't happen. I mean, my experience with judges when I was there for 4 years is we had a judge come before us one time, and I'll never forget it. He said, he was tearing up and crying, and he said, you know, if I get out of this, I'm going to be the best damn judge you've ever seen. And that was the general impression of judges when they came before the commission. They were scared to death, and I tried to ameliorate that concern before they got there and said, just come in and be honest. The commission just wants you to be honest. Come in, tell them what happened, fall on your sword, and this is a forgiving bunch. And this judge got a confidential reprimand, and it was early in my career there, and never heard another thing from him except when I saw him out at judicial events, and he'd always come up to me and shake my hand and thank me and say everything's going great. So I do believe there is a tremendous value in confidential discipline. And I do know you have to weigh that against the public interest, but every infraction does not have to be, in every discipline does not have to be publicly disclosed. So that's the process that we had at the JQC. Again, it's the same rule as the State Disciplinary Board for lawyers. Something does not become public until it is filed in the Supreme Court. Otherwise, it is a confidential matter, and you can look at our annual reports that are online. While I was there, I filed them every year, and you can see the levels of discipline that were imposed. And there are a lot of letters of instruction and a lot of letters of admonition, and those aren't repeat offenders. If someone was a repeat offender, then we would deal with it. I mean, we had a judge that came before us, a Superior Court judge who had been accused of ex parte communications. We had a session with that judge. We said, don't do it again. He got a letter of admonition. Within 2 or 3 weeks, he was back at it with another complaint. And at that point, the commission, frankly, said this matter has got to end. You clearly have not learned. We gave you an opportunity to rectify your conduct, and you went out and you did it again in even a more egregious way. He actually changed, modified an order ex parte, modified a conviction ex parte of a sexual offender not notifying the state that it had occurred. And as you know, that has ramifications for reporting and other things. And what had happened in our midst was that this judge was accused of making phone calls when he came before us, making phone calls to the other side without the opposing counsel on the phone. But then the next time he did it, it was ex parte, but it was illegal conduct, and that judge had to resign.
May I follow up a question on that about open meetings of the JQC? I understand the need of confidentiality when there's being a review of complaints and potential action to be taken by the JQC, but what about regular meetings, just business meetings, considering the budget, considering advisory opinions, things of this nature? Have those meetings, when you were director, were they open or closed to the public?
Chairman, we never had anyone asked to come to the meetings, and we never had that issue addressed to us, whether we could kind of bifurcate the meeting into a public section and a non-public section. But to the extent that we published our annual reports, our budgets, and that sort of thing every year, I mean, we were certainly very open about our budgetary issues, and I don't think our commissioners would have had any issue with having a business portion of our meeting where we discuss staffing and budget issues and those sorts of things. Because frankly, at the time when I came into the commission, as you will recall in 2010, I said in the press that we were on life support, and we were. I mean, we had no money. This body agreed to an enhancement that particular year, the first year I came in. I don't remember what it was, but I think it's like $50,000. And frankly, I would have liked to have had some of those meetings public, because I would have wanted the public to know what our crisis was so they could put some pressure on you guys. As your constituents, to say, you know, this is a problem. You guys need to find $50,000 in your budget and fund this agency.
I think in recent years we've been fulfilling the request of the JQC. I know I'm looking at figures from 2012 to 2016. We've increased it better than 20% budget-wise. We're now over $500,000 a year, $530,000, which staff-wise, you have a director, you have a part-time person who does the administrative work, and the rest of it is private work, or I call it contract work for investigators or otherwise, correct?
That is correct. And I will say, Chairman, the House, you guys have always been, when I was there at the Commission, you've always had an open door. When I came to you and asked for money, you gave it to us. There was one year that we returned $100,000 that we didn't expend because we didn't need it that particular year. We were very good stewards of the money that you allocated to us. I never adopted the policy when I was the director that, you know, use it or lose it kind of thing.
Yes.
And because we had that kind of relationship, and you trusted, I think, what we did with the money, we were good stewards of it, and if we didn't need it, we didn't spend it. And because the work of the Commission, you never know what you're going to get. You never know who's going to engage in misconduct. You can't anticipate, and when you have a very small staff, as you've described, if your caseload increases by 50%, you only have the same people doing the same work. So we were very encouraged by what the reception we got every year from the House, and we got the money we needed. Now going forward, I do think that visioning ahead, as you and I were discussing back in 2010, when we talked about, how do we prosecute these cases? As a director, we needed to either retain outside counsel, which was expensive, or we needed to find volunteers who were willing to do it. And you and I had a very good discussion about using district attorneys.
Yes.
To do that back in, and it was a great idea. And we
out
used
of their own circuit.
Right, out of their own circuit, and you were right. It worked. It worked very well. We got a wonderful assistance when we requisitioned the services of the DA's office. We had 3 district attorneys: Joe Hendricks, Brian Rickman, who's now in the Court of Appeals, and Sherry Boston, at the time was a solicitor, who's now the DA in your circuit. Our incoming DA, we didn't have any issues at all with that. But I think, and not to jump ahead to the recent case, there were some unintended consequences to that decision that none of us knew would happen. And I think what now we realize, as if I were giving advice, I would say that it's probably, even though the cost savings is wonderful and the fact you get great prosecutors to handle these cases, when you amalgamate a disciplinary proceeding with someone who is a criminal prosecutor, you can't expect an officer of the court, an elected DA or solicitor who's taken an oath of office, to ignore if they believe there is criminal conduct. And if they believe there's an obligation to report that criminal conduct to one of their colleagues. And I think that was one of the unintended consequences that none of us would have ever anticipated. And part of being a good organization is looking back and saying, well, it worked really well in these 3 cases. It didn't work very well in this case. So what do we do going forward? And my recommendation to you would be that you do what we have at the state bar. You have disciplinary counsel. You have people who are on staff. You probably only need one. You probably need a director who handles the operation of, who is primarily associated with the investigative panel of the commission, and you have a disciplinary counsel who is responsible for basically being the prosecutor. And they're hired by the commission, and that issue, that tension, wouldn't arise if you had that kind of a system.
I'm going to come back to that in a minute. I want to give Mr. Meadows, Mr. Meadows, do you have any questions you want to ask of the witness? And next would be Mr. Powell. Do you have any questions? Mr. Comer. Let me get your number 19, yeah. See if it works. Try 20, that's right, thank you.
Thank you, Mr. Chairman. We good?
I think you are.
Okay. Thank you, Mr. Davis, for being here.
Thank you.
A couple of questions. You mentioned, you talked a good bit in the beginning of your remarks about the investigation phase versus the inquiry phase of the JQC's process. And as I understood from your testimony, that essentially an inquiry would be somewhat more informal, an investigation would be the more formal process. Now, would the investigation come at the same time as the inquiry, or would they follow separate tracks, or how are they different?
I think you're correct about the inquiry being very informal. The investigation would be where we had, after the initial inquiry, I would generally have a discussion with either our chair or vice chair, and the commission would determine, and usually it was both. I mean, when I was there, I was on the phone every day, multiple times a day, with Judge Allen or Robert Ingram, and sometimes both of them. And before we got into the formal investigation, when we believed there was enough evidence, it's kind of in a criminal context, it would be probably moving from reasonable suspicion to probable cause. I mean, somewhere on that continuum. And it's hard to say when it actually occurs. I mean, there's no necessary demarcation. Sometimes, I'll give you an example of a situation we had with a judge where we had heard about a matter, and it actually involves the same judge I'd spoken with earlier about the ex parte communication and the changing of the order. Mr. Hyde and I had gone to the courthouse, and we were actually interviewing the district attorney. And at that point, that would have been in an inquiry moving toward an investigation, because we were trying to get the documents that were alleged to have been modified. The information came to us by way of the district attorney, who had heard that this conviction and order had been modified ex parte. So we went and met with the district attorney, and of course at that point it was probably an inquiry because we didn't have the documents. We had an allegation, and you trust a DA who calls you that the documents are going to bear out what he's telling you about, but we didn't have the documents yet. So we met with the DA, we got the documents, we got the testimony that no one had been advised, or the statement that no one had been advised at the DA's office, and so Richard and I, Mr. Hyde and I, decided that we would go see the judge. And we called the chair at the time. I don't remember if it was Judge Allen or Robert Ingram. We told them what we had discovered, and they gave us authority to go meet with the judge and question the judge. We went into the back of the courtroom. There was a trial going on. Excuse me. It was pretty crowded in there. I sat on the back row, very inconspicuously.
I somehow doubt it was inconspicuous for the judge. On the
yeah, and well, as inconspicuous as you could be. I think it was one of those things where all the judges knew me, but I didn't know all the judges. And when there was a break, he actually called me forward. He saw me sitting out there, and he said, "Mr. Davis, would you come up to the bench?" And so I approached the bench. And I went up, and he goes, "What are you here today for?" And I said, "Well, Judge, do you have some time? Do you have a minute? I just want to discuss something with you." He goes, "Sure, come on back." So we left. We left and walked around and went into his office. And at that point, I mean, I don't know if I'm in inquiry or investigation. I'm probably in investigation. And again, this is not exactly...
Let me jump in just a minute, because that kind of goes to the heart of my question. You were there with Mr. Hyde in what capacity? What was Mr. Hyde's job? What was he doing there?
He was the investigator.
Okay, so he was not a member of the commission at that time?
No, he was not a member of the commission.
So you went there to ask questions of the judge with the investigator, and is that why you think you were probably in the investigation?
At that point, after we had met with the DA, I'd received information, or Mr. Hyde had received information from the district attorney. So I went and met him there to have that conversation, to look at the documents. And then it was thereafter that we decided, once we confirmed the documents and the seriousness of the matter, and got the approval of the chair or the vice chair to go talk to the judge. Yeah, we were in an investigative phase. Okay. We met with the judge. We laid it out for the judge. The judge admitted what he had done. He said he shouldn't have done it. He understood it was a problem. He said, "I need to resign." He went over to his desk. He started to write a letter, a resignation. And of course, at that point I said, "Judge, this is something you need to think about. And we're not going to do this today. We'll come back tomorrow. You need to talk to your spouse. You need to talk to a friend. You need to talk to a lawyer." We always told judges, you have a right to a hearing. You have a right to counsel. And in that particular instance, the judge said, "Well, that's fine. I'll do that. But you come back tomorrow at 11 o'clock, and we'll meet." And he goes, "And I'll take you to lunch." So we went back to Atlanta. We went back at our appointed time, and we met with the judge. He gave us a letter of resignation, and he took us to lunch.
Okay. So from my question of what's the difference between inquiry and investigation, I think what you've identified as the difference is if you've got an investigator, it's probably an investigation.
Not always.
Okay.
Because with, Representative Coomer, in that situation, and again, I mean, it's such a continuum. At what point does it move from inquiry to investigation? From my perspective, it was not an informal investigation with a docket number, with a case assigned to it, until the commission chair and or vice chair had authorized it. What was happening in the beginning stages is we'd received information from the DA. We decided to go down there and check it out. So that was an inquiry. I was with my investigator at the time while we were doing that.
So what I'm getting back to is your testimony earlier about the Scoggins matter, and you made great distinction that you were only inquiring. There was no investigation on your part at that time. It was just an inquiry. And so it sounds like there may not be such a great distinction between inquiry and investigation, at least from your perspective as when you were the director. So when you inquired of Judge Scoggins about, you made the inquiry with Judge Scoggins because of what Mr. Tate had reported to you, is that correct?
Yes.
Okay. And are you aware that Mr. Hyde, who was the JQC investigator at the time, also went to the probate court in Bartow County and engaged in either an inquiry or investigation type activity?
I'm aware that he went, and I don't know if he went at my direction or the direction of Mr. Tate at the time. I just don't know. I don't recall, and I do know that he went.
Was it the regular, ordinary practice of the commission at the time to have members of the JQC direct the investigator to go and conduct investigations without your involvement?
No.
Okay, so it would be abnormal for Mr. Hyde to have gone and conducted that investigation without your direction. Is that correct?
Certainly without my involvement. I mean, I talked to Richard and the chair and the vice chair numerous times every day. And so I was always involved in the decisions of the commission, and I was always aware of what was being investigated and what was being inquired into. And I don't want to parse those words too much, because I think you realize that I'm not trying to create a different standard for inquiry versus investigation, because it's such a continuum. It's hard to say when something is an investigation and something starts as an inquiry and then it becomes an investigation. But as it relates to Richard Hyde, who is our investigator, would engage in inquiries all the time that may not rise to the level of an investigation because of a tip or something, received a phone call from a judge. And I would reiterate that some of our best information that we received came from colleagues of judges who were concerned.
So are you saying that Mr. Hyde would at times receive those phone calls? He's an independent contractor, not an employee, and he's an investigator. And you believe that he would receive phone calls from judges and then act on his own initiative to go investigate?
No, he would never act on his own initiative. He would receive phone calls. I would receive phone calls. Members of the commission would receive phone calls. It depended upon who the caller was and who they knew and their level of comfort. All of us received phone calls, and all of those were directed and funneled through me and the chair and or the vice chair. There was never a situation where a phone call would come in and someone would act independently on that. I mean, we were a small commission. We all kind of knew what was going on at all times.
So, except that you can't tell me who sent Mr. Hyde to do the investigation of Judge Scott.
I don't remember.
Okay.
I do know that he went up there, and primarily because of the complaint or the information that Mr. Tate had provided, and also to look at the issue involving the courtroom situation. Because what we were doing, Representative Coomer, at this time.
Well, let me interrupt you because I'm not really worried about the courtroom signage. That's not my issue. My issue is you have an allegation of a JQC member who was acting unethically in his role, using his role as a member of the JQC to intimidate a judge into an action in a private case. That's what I'm really
I understand the accusation. I do, and I'm sensitive to it, and I'm as concerned as you are about it. But I wanted to let you understand the context of why Richard would have gone out in a situation like this. As it relates to a courtroom situation, and that's the only thing I wanted to explain, is because we were doing that all over the state because we were trying to educate judges about the new opinion 239, which hadn't been out very long. And if we received information that a judge had a sign on their courtroom, the process was for Richard to go out and take a photograph of it, and then he would go meet with the judge, all with consent and all with approval of me and the chair, and address the situation with the judge. Again, not to bring disciplinary charges, but we were trying to educate. So he'd gone up there for that purpose as well.
Okay. On a different matter, kind of getting back to another point that you made earlier, I believe you said with regard to the JQC and some of the informal positive work that the JQC did you, well, you said that all of the stakeholders are sitting around the table at that point. Did you mean that were you referring to the JQC members as all of the stakeholders?
Yes.
And did you mean by that all of the stakeholders are there because you have appointees from the executive branch and the judicial branch and the bar, and so therefore you have stakeholders?
No. I meant that the representatives of the members of the public, the millions of Georgians who encounter the courtrooms every day, are represented by 2 members appointed. So that is the voice of the citizens.
And those are appointed
by the governor. The voice of the legal profession, the 48,000 lawyers in Georgia, is represented by 3 lawyers who are appointed and recommended by the Board of Governors of the State Bar of Georgia, which is a mandatory bar association, as you know, as a member of that association. And then the judges, the 1,500, give or take, judges in Georgia are represented by the 2 judges from courts of record, is what the Constitution requires, appointed by the Supreme Court. So when I talk about stakeholders, if you think about a courtroom and you think about the justice system, you have the judge, you have the lawyers, and you have the public that are part of that process. So the whole process of the judicial system is represented by those 3 independent stakeholders.
And which of those sets of stakeholders had appointed Mr. Tate to the commission?
The State Bar of Georgia.
And okay. Do you know if Judge Scoggins had ever been given any written? Well, you said you did send him an email telling him you wanted to talk to him, but do you know if he was ever given any written notice of what the investigation or the inquiry was about before you called him on the phone?
I think I don't recall if in the initial email or we emailed and phone called each other back and forth. I mean, we were. I think Judge Scoggins was very aware of what the situation was. I mean, he's going to come before you and tell you. I'm not. He never indicated to me that I had not given him a fair notice of what was going on, and we had a very, I thought, engaging and professional back and forth over this. I think we sent each other emails 3 or 4 times, and we may have talked to each other on the phone at least 2 times.
Did Judge Scoggins report to you the allegation about Mr. Tate coming and making the threatening comments to the clerk's office?
He did.
And when you received that report, what follow-up did you make?
As it relates to Mr. Tate, I think I handled it as delicately as I could. In retrospect, knowing now what I know, and this is maybe where my pastoral skills were more than my legal skills. I probably should have confronted it more directly with Mr. Tate, the allegation. But what I chose to do in that situation, of course not having the benefit of hindsight, was to understand that the allegation was problematic. I didn't want there to be any more tension between Mr. Tate and this judge. And so I viewed my role as kind of stepped in. I dealt with the situation with Judge Scoggins. It was very respectful. The tone was very respectful. It was never antagonistic. I sent him an email that said I understand, his concerns, and that that I certainly didn't apologize, but I would, if I ever see Judge Scoggins again, I certainly would now. I just didn't have the benefit of the hindsight now of what was going to happen, and I should have directed it just in terms of letting Mr. Tate know what the allegations were. But Mr. Tate was aware of the allegation as well, in my understanding, because he was going over to the court. And let me try to turn this one off, I think. He was going over to the court, and he kept filing pleadings with the court, and he kept engaging. Let me turn one of these off. Okay. He kept engaging with the judge. So he was having his own engagement with the judge, and I think Mr.
Private attorney, no?
Yes, in his role as a private attorney, about this pleading that he wanted to get filed. So there was all this back and forth between him, the judge, that I really wasn't involved in.
Okay, let me cut to the core here. You have an allegation of a JQC member who's engaged in some misconduct. You have at least the allegation. You were the executive director. Of course, you worked for the JQC. You're hired and fired by the JQC. Did you report that alleged misconduct to any other members of the JQC?
I don't recall that I did.
Did you report that alleged misconduct to any other person or any other body?
No.
And I think your testimony earlier is that the only process for any formal action to address that kind of misconduct would be through, under the current system, would be through an impeachment process in the General Assembly. Correct?
That's correct. But Representative Coomer, I want you to understand the context of it. As we look back on it now, I think there's a magnifying glass over it because of other issues that have occurred.
At the importance of the workload.
No question. And at the time, what I knew was that there was an allegation that Mr. Tate had gone in there, tried to file this document, and said, you need to file this document because I'm a member of the JQC.
Right, as we have affidavits.
Yes, and that's, and I don't want to make any trouble, but I just want you to file this document. I am a member of the JQC. It's the kind of do you know who I am kind of thing, and so at the time, having the benefit of perspective now. And maybe it's something I should have addressed to the full commission, but at the time I just didn't. Yeah, do you know who I am? I'm a member of the commission, And, you know, I didn't think that, I just wanted to tamp the situation down, deal with it, and move on, and not participate further in it.
That really is kind of why we're here, is because it was easier for the commission and made better sense publicly for the commission to tamp it down than to expose and address it. And so now we're here because we have to expose and address it for the benefit of the public who needs the JQC to be reliable.
Well, and I agree in the context of everything we're dealing with now, absolutely. But at the time, it didn't seem as major an issue from my perspective. And it was an issue, and the way I dealt with it was not to pursue it anymore. That's how I dealt with it. And there was an issue with the open court matter. We resolved it. And, you know, I agree with you. I mean, looking back on it, I wish I had done it differently. I mean, that's all we can do as public servants, is to learn from our mistakes. And
I'll finish with this. I care about open courts. I care about proper procedure, but that's not what any of this is about. This is about an abuse of power by an official of the state of Georgia who used his position to gain an advantage in a private matter, and there's no adequate process for oversight and remedy for that kind of misconduct. Thank you, Mr. Chairman.
Thank you. Mr. Kelly, what's your number?
17, Mr. Chairman. Thank you. Thank you, Jeff, for being here today. I just have a couple of questions myself. Just so that everyone here, and that may be interested in this, understands the process from complaint to conclusion. I see this 5 steps. I want you to make sure that I'm right here. So step 1 is a complaint. Step 2 is an inquiry. Step 3 is an investigation. Step 4 is a formal procedure or formal proceedings. And then step 5 will be the conclusion. Did I miss anything?
that's correct.
So help us understand the importance of the distinction between an inquiry and investigation. Because a minute ago when you were talking to Chairman Coomer, things that sound like you felt like there's an important distinction. And I'm trying to figure out if there really is.
And at the end of the day, I agree with you, Representative Kelly. It may be a distinction without much meaning, because the reality is that the inquiry stage was usually something that occurred pretty quickly, because we can make I can make a decision about something based upon a phone call, maybe a follow-up with a witness pretty quickly. And then if I believed it was something that needed to rise to the level of an investigation, then that's when I would call the chair of the commission and get approval to do that, because it was more. I guess the investigation was often it's just a bigger step forward. But that being said, I mean, there were inquiries that when, I don't want to give the impression either that there were times when we had received a complaint. There were sometimes I'd get a complaint from somebody and it was so egregious, before I even started an inquiry, I'd call the chair. I'd say, we have a serious problem. And before we even got to inquiry. So I'm not sure that's a distinction that makes a significant difference in the process. I mean, ultimately, matters which were...
So let me stop you real quick. When you're looking at the inquiry stage versus at the investigation stage, we can never say that at the inquiry stage, you or Mr. Hyde were involved. And then when you got the investigation, that's when you notify the chair, because that, you said it could be mixed up. You could have the chair being involved before an inquiry. So there's no way of determining at what certain stages between inquiry and investigation who would have been of knowledge.
And I think that's fair. I mean, I think that what I want to underscore through all of this is that we never proceeded in an investigation or inquiry on a matter without the commission, without the chair at least, knowing about it. I mean, I talked to Robert Ingram. I mean, he will tell you multiple times a day, and Judge Allen before that.
At what stage in the five-step process do the other members of the commission become aware of what's going on in a particular complaint?
Our meetings were just about every 3 weeks to 4 weeks. We met often. We also had telephone conferences on an emergency basis, and we sometimes would move more quickly in cases where there was a threat of harm, where we had a judge, do something that was we believe needed immediate attention. We would bring that matter to the full commission. And the commission had voted to authorize the chair and the vice chair to act in the inquiry and investigative stage. But probable cause was never determined until the full commission was aware of the situation.
Help me understand, and others understand too, the difference between a formal and informal disciplinary sanction.
An informal sanction would be something where we call them letters of instruction. They don't constitute discipline. They're basically a finding that even though there was a violation of the canons of judicial conduct, the level did not rise to a disciplinary sanction, and we wanted to handle the matter in a informal way. And the best way I could describe that is the work that we did on open courtrooms around the state. We handled all of those in an informal manner by contacting the judges, letting them know what the new opinion was, providing a copy of the opinion, letting them know that there were signs on their doors that they may have not even been aware of that needed to come down because they created a perception that certain members of the public were not allowed in a public courtroom. Those were all handled on an informal basis with no discipline at all, no sanctions at all. A formal process is where you have an investigation, where you have a case which actually receives a docket number that comes before the commission, where the commission reviews the evidence, reviews the information, calls the judge in. Every judge is entitled to come before the commission before a formal proceeding can be filed against the judge. And so often judges would take advantage of that.
Take a break. Would you at a point where you want to take a break? Or
I'm almost finished.
Okay, go ahead. Thank you.
I appreciate you kind of stepping through of where we're at in terms of what a formal proceeding means. It sounds a lot like it's referenced in Rule 4 as a formal hearing. Witnesses are called, and y'all have opportunities to issue subpoenas, correct?
Correct.
You know what authority y'all have to do that outside of these rules?
Outside of the Supreme Court authorizing the rules, that would be the authority. The Constitution allows the Supreme Court to have rules, and the court approved the rules that allow the issuance of subpoenas to compel testimony and evidence at hearings. The hearings are subject to the Civil Practice Act and the evidentiary.
Y'all are a trier of fact.
A trier of fact, but we also, the commission would also make conclusions of law, which would be these facts. In this particular case, there was a finding that the conclusion would be that a canon violation had occurred, and then there's a recommendation of discipline to the Supreme Court in the final order of the commission after hearing. So there.
And I'm through after this, Mr. Chairman.
No problem.
I want to thank you for being here, and just ask you, we know you came voluntarily, but do you see any irony in the fact that the JQC has pushed so much for openness and access to proceedings, and yet they fought this committee so much in terms of turning over any documents or participating in any way?
Well, all I can tell you is that I'm here because I believe in the commission and I believe in the work of the commission, and I'm here to accept criticism where it's appropriate, as Representative Coomer has pointed out. When I was there, in less than 4 years, I handled over 50 matters involving judges who had to resign from the bench. It's messy work. It's difficult work. But it's necessary work. We can always do better. I can do better. As overseers, you can do better. And I'm here to be part of that process. Understanding, like with appointment of DAs, it sounded like a great idea. It worked well in 3 instances. It didn't work so well in 1 instance. A situation occurred in a courtroom where we had a commissioner go in and allegedly create an issue. It didn't get addressed the best way that it could have. And I take responsibility for that. But at the end of the day, I hope you will judge the work of this commission on the whole, on what we've been able to do, and what, as difficult as the job is, disciplining powerful people and holding people accountable to the public trust is a difficult job. And I want to ensure that at the end of the day, that all the stakeholders who are involved in this process have a seat at the table, because I think it's important. And I just caution you not to allow one incident or one situation or even one commissioner to go back over the course since 1972 of what this commission has been doing and the work of this commission and the great work of the commission. Is don't allow those instances, which are serious, which are matters which need to be addressed, don't allow that to color the great work of the commission, and to allow us to as it relates to the organization I represent, which is the State Bar of Georgia. The State Bar of Georgia has given you, in terms of appointments, some of the finest chairmen that the commission has ever known. While I was there, I served with Ben Easterlin, who took the commission through a very, very difficult time of unprecedented resignations that we have never seen before. Sometimes 2 in a day. Sometimes entire circuits where Superior Court judges in entire circuits resigned within months of each other. Ben Easterlin was appointed by the State Bar of Georgia, and I am glad, as a member of the State Bar of Georgia, that he was there at the helm. Robert Ingram, I'm glad he was there at the helm. Before him, many, many lawyers, many great judges who were there. So all I ask you is to not allow your perception of the commission to be colored by a singular event or a singular incident or even 1 or 2 commissioners. It's bigger than that.
But as I said earlier, when the commission fails one, it fails all of us.
I agree with you.
Totally.
I agree with you.
And there's no other way of oversight to correct those things, because the commission answers to no one.
And I agree. I agree with you, Chairman. And that's where you've got to ensure that there are ways in the future, if this ever happens again, and if there ever is an incident where you have to address something, there is a mechanism in place.
That's right.
To do that.
We're going to take a lunch break for, it's now 1:12, I'm going to say, until 1:35 or 1:40. If we get back in here, we've got lunch in room 415 next door, I believe it is, for the committee members and our witnesses today.
Thank you.
Not quite through with you yet.
That's fine. Just feed me and I'll be back.
Testing 1 2 3. 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 Testing 1 2 3.
Speaking of which, actually, I have to leave this early. Who's the next?
There's no agenda.
I know. I heard you say that.
Testing 1 2 3.
It's kind of crazy. But you know, they are exempt. They do not, even though they're under their own rules in the House and Senate, they hold the meetings open. They provide agendas and documents, generally speaking. They are exempt from the laws that require other agencies to do that. Yeah, it does.
It's just kind of hard to know. It's been a while since you had anything that was other than that.
They don't file constitutional amendments to get rid of someone who's already.
You have the Dutch, you're getting all the right. Fine engineer said that there's a short in the back.
Testing 1 2 3.
And so
Mr. Kelly's not here, but I assume he was through with his questioning. And
That's what he told me in the hallway.
all right, and I'll turn to Ms. Oliver.
I also want to thank you very much for being here. It's very helpful.
Good.
And I think this is a good discussion about some possible substantive procedural issues that we want to get right. In relation to the inquiry to investigative stage, what policy is best, in your view, as to when a judge is notified? And I'm a little uncomfortable with notified by phone. I'm thinking about the correctness of the state bar policy where you're notified with a letter when any complaint is made. Talk to me about that. When should a judge be notified in writing, and should it be inquiry? Should it be on investigation? And I'll tell you, although I'm probably more sensitive to judge in my circuit, Judge Becker, and Chairman Coomer may be more sensitive to the judge in his circuit. I've had other judges, reputable men and women, who've told me the first time they were informed of a problem, complaint, inquiry, was when an investigator showed up in their office.
Right. I think it's a public policy issue as it relates to notification to a judge. First of all, I believe that the best practice would be at the time of the investigation, when it becomes an investigation, when it's moving from inquiry, which is very informal, and again, that stage is usually very short. When a call is made, or either the investigator or the director puts this information together and calls the chair of the commission, gets authority for an investigation, I think at that point there should be notice to the judge as a policy matter. But I will say this, you need to always have an opportunity for the commission to make a determination based upon a specific circumstance in a case where a judge would not be notified because it would perhaps create an issue for a witness. Let's think about the judge in North Georgia who we were investigated alongside with the GBI at the time, who had planted the drugs on our witness who had come forward. We were well into an investigation, and the judge at that point was not aware that we were investigating them, and it frankly would have created, I think, problems for the GBI's investigation and them gathering information, and it would have created possible safety issues for the lady who had come forward and was now a witness against the judge, and the judge was being pursued on an investigation, both criminally and with the JQC. So I think that any policy needs to have an exception. But I think as a general rule, the timing should be at the investigation stage when there is a case number, a docket assigned to it, and I agree that it should be in writing, that would be the appropriate means by which to notify a judge of the investigation.
Let me go to what you touched on a little bit during your earlier comments, and that was about the two judges who have been indicted. And I believe their indictments grew out of their being invited to come to appear before the JQC in what I'll call an informal meeting. And these indictments grew out of what I understand. I don't know much about Judge Williams, as much as I do about Judge Becker, of course, but because Judge Williams is still a pending case in Fulton Superior Court, has been for several years now, like many things there. But the issue there, I guess, comes down to, you mentioned the assistant district attorneys or district attorneys assisting the JQC in the matter before a judge's appearance. And I guess the question is, how is decision reached, if there is one, with respect to the question about a judge's statements being untruthful or perjured? Who makes that decision as far as comparing what is other information versus what the judge has said? Go through that process as far as the JQC when you were there?
Mr. Chairman, it's a great question, and I do want to distinguish the two cases, the Judge Becker case, which I was not involved in, and the Judge Williams case, which I was involved in. First, I'll start with the Judge Becker case. It is my understanding that that case, there was a referral which was made by the district attorneys who had been requisitioned to handle the disciplinary case against Judge Becker. My understanding is that they made a referral to the Cobb County district attorney based upon their review of the case, their review of the file, to determine whether, in fact, Judge Becker had made false statements to the commission when she appeared before the commission in a meeting which was held in Cobb County. My understanding is that the district attorney, Vic Reynolds, recused his office because of I think his deputy used to work in Judge Becker's court, asked the Attorney General to appoint a special prosecutor, which the Attorney General did. So in that respect, that was actually a referral which was made by the prosecutor within the context of their work on the disciplinary case. And I'm just, this again, because I wasn't involved, I'm just assuming this. At that stage of the proceeding, the commission is no longer involved. Once the commission determines to file formal charges against a judge, when I was there, Judge Allen, the policy was once the formal charges are filed, they put on their judge hat.
I know.
And so there's no involvement with the prosecutor.
Well, the question
so the commission would not have been involved in that decision if it was following the policies that were in place when I was there.
I understand that that person who is an attorney also has another role as a district attorney, prosecuting attorney. The work they're doing, though, is a work under the direction of the JQC, is it not?
Well, they are, but they're not being controlled by the JQC at that point because the commission is acting in a judicial role, and that's the problem with having a non-bifurcated system. And we were very scrupulous about that when I was director. We were, after the commission determined that there was a finding of probable cause and decided to file formal charges against a judge, the commission was not involved in choosing the prosecutor any more than a judge would be involved in choosing a prosecutor. They didn't have any involvement with the case. They didn't put the charges together. So in this instance, when the referral was made, it was made by the disciplinary counsel, who happened to be a district attorney. It was made to the another district attorney.
Stop right there. But does not the JQC, as to the role of that person who is an attorney under the services and direction of the JQC, is that correct?
That is correct. I mean, they're employed. They're employed to do the job by the JQC.
At that time, they're sitting as an attorney, not as a prosecuting attorney. They may have a role outside the JQC as a prosecuting attorney.
They do.
And my question is, does not the JQC have any say-so as to, well, we brought this judge in, are we going to now allow somebody to go prosecute them without getting some direction from us since you are our attorney?
Well, I think the JQC should probably have a role in that, but
exactly.
in this instance, I don't know whether they did or not. And we never had this situation occur.
Go back to Williams. You were there under
I
Williams.
was there for Williams.
What role did the JQC at that time have with regards to whether a prosecution should take place of Judge Williams?
We investigated the Williams matter. We brought Judge Williams before the commission, and we invited her to come. She came with 2 lawyers. She appeared before the commission, gave information and testimony before the commission. I subsequently met with her attorney who was representing her. I actually drove down to Brunswick to meet with him. Told him that we were going to be filing the charges, tried to negotiate a disposition.
Charges with the of what you mean as far as
Formal charges against
disciplinary or
disciplinary.
criminal?
Disciplinary.
Okay.
We had nothing to do with the initiation of the criminal charges against Judge Williams, and I'm going to get to that.
Okay.
We were proceeding on only a disciplinary case. We weren't proceeding, we had no design on proceeding against Judge Williams on a criminal case. We charged her in the charging instrument through the attorneys who had been selected to prosecute that case. Judge Leah Sears, maybe in Ward at the time, was one of the attorneys, and Mike Bowers were the 2 who were selected, neither of whom are prosecutors, neither of whom are district attorneys. We were proceeding on that case as a disciplinary case only. We filed the formal charges. If you will remember that case, it received national attention. There was a radio show on NPR that Ira Glass had done an expose on the drug court.
And I'm not worried about that.
Yeah.
I understand the disciplinary part of it. And no questions are being raised here whether that was appropriate or not. My question is regarding the movement of just disciplinary now to a prosecutorial issue.
Okay, and let me tell you how that happened.
All right.
So we're proceeding on the disciplinary case. We filed the formal charges in the Supreme Court. The formal charges are now public.
Yes.
There is a newspaper article from December, I believe it was 14th, 2012, in the Brunswick News, where a reporter asked the district attorney in Brunswick, who is Jackie Johnson, had the charges, our disciplinary charges, and said there appear to be possible criminal issues with this charging document. Of course, we weren't pursuing criminal charges, but this reporter asked Jackie Johnson about the possibility of a violation of oath of office and some other things that had been alleged. And Jackie Johnson told the reporter that she was referring the matter to, she was recusing her office, she was referring the matter to the Attorney General's office, which she did without our involvement. I never spoke to the district attorney in Brunswick, never had any conversations with anybody in her office at any time about Judge Williams or anything else. We had no involvement with Jackie Johnson. She decided on her own accord as a district attorney, after she reviewed the charges, to refer them to the Attorney General's office. The Attorney General reviewed the charges and looked at them, and the request, he got a written request from District Attorney Jackie Johnson. He appointed District Attorney Paul Howard as a special prosecutor to inquire into the matter. Sometime later, months later, after we had resolved the charges with Judge Williams, there were no criminal charges pending against Judge Williams when we resolved the charges with her. There was never any intimation that there were criminal charges pending. I dealt directly with her attorney. We negotiated her resignation, and she left the bench. It was after the conclusion of that Paul Howard, the district attorney of Fulton County, got the matter began to investigate it. In addition to that, because of the publicity of this case, the U.S. Attorney in the Southern District contacted, through the FBI, our office to inquire about the matter. Grand jury subpoenas were issued by the U.S. Attorney of the Southern District to the Commission. Again, all of this was after the disciplinary case was over. We initiated none of this. We didn't ask for any of this. We were merely responding to an investigation by the special prosecutor in Fulton County and the U.S. Attorney, the Assistant U.S. Attorney, Jim Durham, in the Southern District. So I want to distinguish, because I think it is critical to understand the difference between the Becker situation, which was a criminal prosecution that was occurring during the time of the disciplinary case, which was, from what I understand, purportedly initiated by the prosecutor who was chosen to prosecute the case in that particular instance. That is not what happened in the Becker case. I mean, in the Amanda Williams case. And I would have never used or allowed a criminal process to be used in a proceeding to try to gain some advantage or leverage or anything else in a disciplinary case with a judge.
Right. As I understand, the Williams matter was or grew out of the fact that she appeared before the commission, and there was a question of whether or not she was being truthful in her statements to the commission at that point.
That was one of the allegations. The U.S. Attorney's Office for the Southern District was investigating her for possible violations of
Did they do anything?
Civil rights. They convened a grand jury. They investigated it, and then from what I heard, they decided not to pursue charges against her. The case against Judge Williams, which, as you note, is currently pending, is my understanding is it's not just about alleged false statements to the commission. It is also about the possibility of her violation of an oath of office.
Out of what? Growing out of what?
Growing out of a growing out of a situation which occurred in open court, where she made a statement in a court reporter's microphone about providing favorable treatment to various defendants in the drug court based upon political contributions and favors that she had received from members of the bar.
Is that part of the indictment against her?
I don't know if it's part of the indictment against her, but that was some of the allegations which were being investigated by both the U.S. Attorney's Office and Paul Howard's office. I've never seen the indictment against Judge Williams.
I haven't either. I've read part of a transcript where there was a hearing, and the only thing being discussed as part of that hearing was testimony or comments made by her before the JQC.
Well, and again, I know that was part of the investigation were purported comments that she made which may have not been truthful. That was part of the investigation conducted by both the U.S. Attorney and Paul Howard's office. But again, those weren't charges that we pursued or asked them to pursue.
I guess the reason I bring these up, and I'll close this comment about it, and we do know what happened to Judge Becker. When I first heard about and read about Judge Williams, I was saying, whoa, that's she must have really done something bad to get indicted as a person who was a judge, and felt there's got to be some egregious conduct there. Then when it happened to Judge Becker, and I read more and more about it, it raised a lot of concern about two things. To what extent the role of the JQC was in pursuing criminal actions against a person who they invite to come before them and speak informally. And I say informally, neither one of them were put under oath, but there was a review by the commission, which is a governmental body, and we know there's a statute that covers that. But the problem is, it to me destroys one of the strong purposes of the JQC, which is, as you know, to have ability to bring in judges and talk to them about situations, and now doing so with the fear that if I go and talk to the JQC, and we'll talk about Becker case later, then the fear is I'm going to be indicted. And so who would want to do that?
I agree with you. And when I was director of the commission, we never pursued criminal charges against any judge for allegations that they had made false statements to the commission. And I agree that you are going to seriously undermine the capacity of the commission, as I testified earlier, to do some of its best work, which is to invite judges in to have an opportunity to discuss cases with them. I do believe that pursuing criminal charges against a judge for those types of violations, especially when a disciplinary case is underway, is very problematic. And the larger public policy is that it chills the ability for the commission to do the necessary work that it does. And so I'm here to say, when I was director of the commission, that was never our goal. And we wanted judges to come in, and we wanted them to have an opportunity to say what had happened. But by the same token, we expect judges to be truthful. And to the extent that judges make false statements to the commission, that is a problem. And that's something that is, as a commission, as a disciplinary matter, should be addressed by the commission.
Yes, sir.
And we expect, as you expect me, I was put under oath earlier today, and if I make a false statement to you, I can be accused of perjury. But if I not raised my hand and not been sworn, I could still be brought up on criminal charges for making a false statement to you because you're a governmental body. Both of those are felonies.
Yes, sir.
And there's an expectation that I will be truthful to you, and when I appear before you, that's the expectation you should have of me. And that's the expectation that the commission had of judges when they came before us.
Thank you, sir. Anything else further that any of the committee members wish to ask? With that, Mr. Davis, we are closing out your testimony, and I want to again personally thank you. Thank you not only for appearing today, but certainly thank you for all your public service over the years.
Thank you very much.
And great to see you again.
I'm happy to be available to this committee as you go through the process of finding better ways to conduct the commission, and I appreciate the opportunity to appear before you. Thank you very much.
Thank you.
Thank you for your public service.
Next we have is Judge Lane, who is also in the audience. Judge Lane, you'd like to come forward, please, sir? And I'll have Mr. Robinson administer the oath.
You solemnly swear that your testimony will be the truth, the whole truth, and nothing but the truth?
I do.
Would you like to have a seat, Judge Lane, and give us your name and your past involvement with the JQC?
My name is Ronnie Joe Lane. I retired and took the position of director when Jeff Davis went to the state bar, and did it, I don't know exactly how long.
Okay.
We had a dispute about pay, and
yes, sir.
I decided I was way too old to put up with that kind of, we call it crap at home, but
okay.
I went home and retired.
Do you recall about,
retired,
did you recall about the time frame that you were there date-wise at the JQC? Can you tell us?
I know August 1 is when I started.
What year? 2014?
It would have been 14. And in the fall of, I'm not sure. I mean, if it's important, I can get back to you with those dates.
No problem. Was it over or less than a year, if you recall?
A year.
About a year's time. All right. Who was chair of the JQC during the time you were working with it?
Robert Ingram, and then Lester Tate.
And when did Lester Tate take over?
Geez, I don't know. I don't know the date.
Okay.
We can get those records from the office. They have it.
Understood. We've given the witnesses a chance to provide an opening statement. Do you have a wish to give us a statement?
My statement is to all of you that you understand how really important what you're doing is. I want you to understand that. I started practicing law in 1975 in a circuit that had a tyrant judge. He was a tyrant. He was awful. And he treated not only lawyers but members of the public, even jurors, with utter contempt. He was a very unhappy man, and he decided it was the best thing for him to do was make everybody else unhappy. And he was sort of like, I don't know, I was never in the Marine Corps, but it's sort of like a drill sergeant in terms of the way he ran things. It was his way or no, absolutely no. I'm not sure when Representative Powell came back. What year did you?
77.
Well, he got a little taste of it, probably, in our circuit. But he knows. Some might say his judge was a little bit rough around the edges. I'll let him. If y'all want him to testify, you can ask him later. But in any event, he was that way, and then he luckily for us committed suicide, and for the rest, we got some relief without the because the JQC at that point was doing nothing.
Yeah.
It did nothing for a long time. It was just a figurehead. Didn't do anything that I could see. If it was doing anything, it didn't come down South Georgia way. And so we ended up, it got a little better, and we had a judge in Bainbridge that was just way off base, state court judge, and the JQC finally got him out. And that, I got interested in that. And actually, I ran for election in 2000. And I had been elected, so it would have been fall of 2000. And he got a public reprimand in the courthouse in Bainbridge, issued by Wallace Cato in open court. And I went. I had been elected as Superior Court judge, but I hadn't taken office yet. And it was interesting. I saw what could happen, with removal of judges. And then, I don't know, later in 2006, I believe it was around 2006 when the Jeff and Richard started really doing something, as opposed to not doing anything. There was a period there where the JQC just wrote letters. They called them letters of instruction. Is what it was. It was, quit doing that. And don't do that. That's not nice. Don't do that anymore. And they did that for a long, long time. And then Jeff and Richard came along and started down in South Georgia over in the Alapahaw circuit. I won't go into, I don't want to call names, but that case was Blitch. Well, you can call it. It was a great piece of JQC work. Resulted in his retirement, his resignation, and it got on, and it just gotten really. I thought the commission's work was better and better, and it was. It got rid of I think the total since Blitz, 66 judges have resigned or been removed. Almost all of those were resignations because we've only had. Well, even Amanda Williams resigned, and Judge Becker resigned.
They had 2 trials, as I recall.
Yeah, I think it's 2 in a period of time. But I want you to know that your job is important because what can happen here, we can go 2 ways. The commission can be neutered and rendered totally ineffective, or it can be made better. And Jeff just pointed out, even if you are convinced, as I think at least some of you are, that the commission's actions in 2 cases weren't proper, the other 64 certainly were. And I can't think, personally, reviewing those cases, I don't know of a single judge that was removed during the period of time that I'm talking about that I would want back on the bench if I had to practice law in front of them, because of their temper, their demeanor, almost tyrannical conduct, and you know because you're lawyers. I mean, except for what happened to our other Marine Corps?
He left for another appointment.
Okay, I was going to give him a hard time, but nonetheless, it's important, it's critical that we do that. And of course, I want to address your concerns, if you have any. And I made some notes on, there are a few points that Jeff and I agree with 95% of what he said. There are a few points in there that I would fine tune if I were getting to make the final decision, which I'm not, about how to do this job. I will say that I got the sense from listening that a lot of these problems are problems that should be correctly dealt with by the Supreme Court in their rules. Because if you think, for instance, that some judge ought to get notice at a certain time, if it's in that rule, I am satisfied that the new director, the new commission will follow those Supreme Court rules as best they can. I know that we always tried to when I was there, and I know that Jeff tried to personally, because he and I would talk. He and I would talk about issues when I was still a judge. He'd call me up and said, "Well, just Judge so-and-so is telling me he does this. Do y'all do that down there?" I said, "No, nobody does that like that in the state, like this unauthorized surcharges we had in Grady County. Nobody was doing that except this one judge. He had an unauthorized, illegal $750 to $1,000 surcharge on the DUI cases that he kept, and it went into the county money. It didn't go to the state. Y'all never got it up here in the legislature, in the budget. He kept it down in the county. Now, that was just, he said, "Oh, everybody does that." And then after he found out that wouldn't sell, he said, "Well, nobody says I can't do it." And there actually is a statute that says you can't create a surcharge, right, that y'all passed at some point. But I would certainly just defer to your questions. I made some notes, but I'll skip those and address any questions that you have.
Well, thank you, Judge. Let me go. I think during the time that you were in tenure with as director of the JQC, it overlapped this one case we're talking about, Judge Scoggins, for instance.
All right.
And I know you had some involvement with that for taking over when you started as director. Tell us about, and Mr. Corman may want to go into more detail, but tell us about your involvement with Judge Scoggins' issues, please.
Lester Tate told me that he was running a improper court. Would I go take a look at it?
What was he saying was improper of you?
He was he was running it more of a revenue court without any concerns for whether the people had a lawyer, whether they understood their rights, limiting access to the courtroom. And of course, I didn't know if any of that was true. And I don't know if it's an inquiry. Who was that? I don't know if it's an inquiry or an investigation. But I went up there, and Richard was working on several other what I thought were higher profile issues at that time. And I said, well, that's something I can do because I know more about how a court's supposed to run and look than Richard did. I mean, he was a cop.
You speak of Richard Hyde.
Richard Hyde,
right.
Yeah. He has a very slanted view of rights and everything else. I mean, policemen are not who you want to ask. Well, are these people's constitutional rights being protected? Don't ask a cop that question. No, but anyway,
Where's that letter?
I go up and I go into the courtroom. Well, I got down, and you're from up there, aren't you?
Yes, sir.
Have you been in that courthouse?
Last week.
Okay. Well, I went in that long hallway down there where he has court. And there were probably 250 people in the hallway. Nobody in the courtroom. I was going to go on in the courtroom, but it was locked. The door, there was a big deputy at the door, and nobody could go in. And I had on blue jeans, and it was cold, I remember that, and a leather jacket. I sat down in the hall with all the other criminals, and I sat and waited. And luckily for me, he came out and said, he didn't, the bailiffs announced, if your name starts with A through L and you're a defendant, you can go in. Well, I snuck in. I really wasn't a defendant, but my name did start with L, so I went in with that first batch of people. Nobody from the public was let in, except there was one lady who talked to me because her son, who was about 17 or 18, he was a defendant, and she got to go in with him. And they just had court for the A through L's, and no public there was nobody at that time. Nobody in the public got in, and we're trying to push. So I sat there, and he goes through the calendar for the A through L's, and I had seen everything I needed to see, and as I was leaving, the judge asked me, "Do you have a case?" I said, "No, sir." And he said, "Well, what can I help you?" I said, I'm from the JQC. I'll be in touch with you. Don't worry. I'll be in touch with you later. And I left. And I wrote him a letter and said, I'd like to have a copy of the tape. When he came out, he had a clerk with him. She laid a tape recorder down right there and turned it on. And it played throughout that morning session. Well, I get a letter back. You won't believe this, but the tape was accidentally erased. Now, I don't know if that's true, but I'm not a big believer in coincidences. But that record is lost forever.
But did you observe, besides the fact that the question of whether or not the courtroom is accessible by the public, did you observe anything unlawful?
Oh, yeah. Well, procedurally just weird and denial of rights. They would go up and he would tell them, if you want to plead guilty, go down the hall and talk with the DA. And there's a public defender down there. They got a hall. They had a room in that same area down there. And they got windows like a bank. And if you want to pay your fines, you pay your fines. It's just, it doesn't favor court. There are dispositions of cases without any judicial involvement.
Yes, sir.
But now that's just, and I was absolutely at that point going to try the pastoral approach of Jeff Davis, which would be to say, hey, Judge, why don't we see if we can change this and do it more like other courts? And he pointed out in his letter to me that he was trained to do it that way, and that every other magistrate court or traffic court, but whether it be probate or whatever handling traffic courts, they were state court judges. Bob Bray's back there, and he said and apparently Bob's got some kind of classes that teach them to do that way. Okay. But I'd never seen anything like it. And I'm reminded of my friend Brad Hornsby, who said that he had been everywhere but the electric chair and seen everything but the wind, and he just never seen anything like this. Okay. But I felt the same way about it now. And whether or not there would have ever been any disciplinary action taken by the commission, I wanted to see if there was anything worth looking at. And I just wanted to hear, I wanted to really to go through and carefully look at what he was actually telling the people when they came up. And I never got a chance to do that. And I never went back because we had other stuff that was going on. But that was my Scoggins.
Did you report back to Mr. Tate?
I know I discussed it at one of our meetings, but I don't know what I told him. I never did anything else. I did not believe that the court was being run properly. Now, whether or not it certainly, I don't think it would have led to any kind of removal action by the commission.
I guess, having been a lawyer for too many years, frankly, I've seen those type of courts operate all over the world different ways, every one of them.
And we were doing our best.
Yeah,
I went to every.
I guess there's no set procedural way that you run a municipal court or traffic court,
Well,
probate court handling.
there may not be any real set procedural ways to run them, but there are some ways that you shouldn't run them. And those are what I call sort of the basic minimum stuff.
Yes.
And that's what I wasn't impressed with. But
Judge, were you there during the matter of Judge Becker?
in the beginnings.
Okay.
And now I think again I don't have the dates. I think I left before all this indictment stuff came about.
Were you there as a director when she came in to appear before the
I was sitting
commission?
at the table.
You were sitting at the table. Had you been involved with providing her notice of what she was being asked to come in to do?
And I remember what you said in your opening statements about it. Unless I'm really bad wrong, there is a letter in the file that says we want to talk to you about, and it gives her docket numbers.
I've got a copy of the letter here, Judge.
Does it have anything on docket on it?
Give the judge a copy of the letter.
All right, there's another, then if that doesn't have it, there's another letter.
All it has on the judge is at the very top it says docket, and it has 2 numbers.
Yeah, that's it.
Now, do you sit there and say that is sufficient notice of what?
Well, she had the dockets. She had already been notified about the cases, what the concerns were. She knew what those dockets
I'm hearing
were.
different from her, but I'm saying nothing was given to her that described what may be the purposes that she was being asked to come in and appear before the commission. I say that's one case.
Yeah.
She knew of one case dealing with a lady who was unhappy about the fact she did not renew a default judgment.
And I remember her bringing that up.
And that's the only thing she knew about.
And I remember Robert Ingram said to her, well, if you don't feel like you got notice, we'll continue this. You can come back next month.
Well, I got a transcript of that too. I don't think he quite put it that way, Judge. But
what did he say? I'm not familiar. I
will
haven't seen
pull up
the
transcript.
But now he told her several times
transcript on
that she could come back.
I don't think I read it that way, but I'll let the transcript speak for itself, and that's the public document.
Yeah, and I'll go by whatever the transcript says. But sitting here right now, I recall Robert telling her more than once that the commission would let her come back any time and invite her back. She did not come back, even though she was re-invited. I think we even re-invited her.
I'm reading toward the end of it where Ingram is talking, and it says, the thing, Judge Becker, I want you to understand is I think you've got a valid point on that. We apparently dropped the ball, and I'm wanting to make sure from a due process standpoint that we're fair to you, because when we recognize that the most important thing we can do is make sure the integrity of the judicial system is protected, and we certainly don't want, I can assure you, we do not intend to tell you one thing and bring you in here for another. I can assure you that did not happen. And to the extent that we were caught off guard, I'm sorry, that you were caught off guard with it, that does bother me. And if you feel like you need additional time or whatever to address that or think through it, then I want to give you that. But before we make any final decisions on what we'll do with this. Now, I say that is a statement at the very end after she's already been testified.
And I think you'll find it earlier in there, Commissioner. Mr. Chairman, I think you'll find earlier in the transcript that as soon as she, and I'm going to use this term gently, as soon as she flew hot, he assured her that he would continue that matter. And I use the word flew hot.
Well, it goes back to the issue of fairness and due process, Judge.
Sure.
If she didn't see or know why she was being brought in there to give an interview.
But she's telling you that she doesn't know what these numbers meant, that they didn't stand for separate cases.
I don't.
Okay. Well,
how would anybody know just looking at a number unless they've got something sent to them that tells them what's in these dockets?
I believe she had that sent. Now, if I'm wrong, I'm wrong, but I believe she was sent that. I think
All right.
If not, I mean, if that's not true, then I'm wrong.
Would that be reflected in the files?
Should be, but now.
So if we get the files, we should be able to tell that. Of course, the JQC, I believe, is taking a position. They're going to give us the files.
Well, I think they ought to give them to you myself.
I do
but
too.
Now they hadn't.
As a
They have
public
not
body.
asked me to advise them about it.
Okay. What is your thoughts of anything that should be done as far as restructuring or changing of the way the JQC operates?
I've been thinking about this for a long time. And even while I was there, I thought about it. We were stuck with the system we had. We need to change, and we need to have an investigative panel that I would describe to the lawyers in here as being more like the grand jury, with the director and his investigators serving in the role of the DA in a criminal setting like that, to investigate and bring charges, and not just that, but to accept voluntary resignations, to accept agreed on punishments. Like I'll agree to a private reprimand, and we had one probate judge that agreed while I was there, that she agreed to a 6-month suspension without pay because she lied about her continuing education requirements. She said she had to have some tutoring or mentoring by another judge. That was part of the system. And she just lied about having done it. And the other judge called us and said, hey, I didn't do that. I had never seen her. She never came to me. Well, that sanctioned, the commission voted to allow her to do a voluntary suspension. And it probably was okay. I mean, she learned her lesson. I think she had a really good lawyer who came in and fell on the sword for her. And in criminal cases, that's always the advantage. The less your client says, the better. Yeah. They need to be able, this investigative panel needs to be able to do all those things. And then once a case is charges are made, then have I'd say 5-member, minimum 5-member, maybe 6-member trial panel. They might not even have to work but once a year or twice a year, or maybe less than that, honestly. But have them and let them be separate from the investigative. Don't even go to the same meetings. Don't go to the bar together. Don't socialize. I mean, just like a standoff type deal, and the adjudicatory panel would decide whether or not a judge has violated the rule. Leave the investigative panel doing what basically the JQC does now, which is, but the only difference now is they sit around, they take off their investigative hat and put on their judging hat and decide whether the guilt or innocence or violation or not has happened. Something like that. The JQC members aren't paid anything, so it wouldn't cost any money to have 5 or 6 members on a panel that decide these cases. It wouldn't even cost any more than it's costing now, so it's not like we're asking that. Where you might want to look towards the future is to have, as Jeff was talking about, a prosecutor on board to prosecute the cases. Now the director, if he was a lawyer, he could do that. Yeah. But if he's not a lawyer, he would have a hard time, I think, knowing the rules of evidence and that kind of stuff.
You mentioned earlier that talking about the current setup, and you mean by current setup the way the Constitution sets up the JQC, it doesn't allow for that type of.
We don't have any way to have a separate panel.
That's right. It's not flexible. It's just a set 7 number, and that's all JQC members.
Yeah, I mean, the Supreme Court, I guess technically could, by rule, could divide it into 3-member adjudicatory panel and a 2-member investigative panel, but they'd still be one panel. I think they need to be separated if you're going to do this, so that there can be no feeling of pressure by one panel on another panel.
Well, we'll go back to earlier about being fairness due process.
Sure,
is the way
and it's
things
not
happen.
just due process. It is the appearance of due process, because what it looks like to people is what it is in their mind, and it never changes. It never changes. If someone, a layperson, goes into your courtroom as a judge, and he comes out thinking, I got a raw deal, that guy wasn't being fair. Even if you were, you just ruled against him. That's the facts as far as that person is concerned. And he'll carry it to his grave, always thinking bad about it. And that's why it's so important that judges do this stuff right, that we not walk in the courtroom and chit-chat with the lawyers on one side, because we know them. And the guy from Atlanta comes down to South Georgia, and we don't know him. He's standing over like, and you just look over, oh, how you doing, and that guy feels like he's got home cooking, even though he may well not. I used to rule against my hometown lawyers way too many times, and they would whine, and I'd hear them whining later, but they'd whine. They were whiners a lot. We have a lot of whiners in South Georgia.
Lawyers sometimes inoculate that way.
Yeah, I just.
We hate to lose, you understand?
Well,
whatever the reason, we just hate to lose.
I know that, but the judges, even at the lowest level, and I'm talking about magistrates, probate judges, municipal court judges. I think they finally did away with that Atlanta hybrid thing called the Recorder's Court. I think they flushed it, didn't they, this recently? Well, that was a blessing. But that's the face. More people see them than see the Supreme Court.
Absolutely.
Most people don't even know who's on the Supreme Court.
Ms. Oliver.
Thank you, Judge, for being here. It sounds like you agree with Mr. Davis that the policy would support a confidential reprimand or a confidential determination of some inappropriate act of a judge.
Yeah, I think if you don't do that, we cannot adjudicate 700 cases a year. We can't do it. The commission couldn't do it, and I say we. The JQC cannot fully investigate. What's the other word we have? Inquiry. They cannot make inquiry. They cannot make full investigations. They cannot do the whole batch, the whole 9 yards on 700 cases a year, not staffed as it is now. And in reality, and I don't know that anybody's ever explained it to you, but now when I was there and I was told it was the way we did it before, I wrote what I commonly referred to my secretary over there as a flush letter on probably over half of the complaints that we got. I'd read them. I said, this is BS. There's no way, it doesn't need to go any further than my desk. And I wrote a flush letter to the person that complained. And most times, I did not send a copy of that to the judge. You say, well, why? Doesn't he have a right to know? Well, maybe he does. But does he really need to know? Because he then might retaliate against that complainer. And my Lord, then we've got a real JQC complaint against the judge for retaliation against a litigant because they had actually reported what they saw as misconduct, which wasn't. So we, a lot of times, didn't tell the judge he'd ever had a complaint. And I think that's the way it ought to continue. Whoever does this ought to be able to do that. And you have got to do triage at the JQC. You got serious cases, you got some others, and you got some that need flushing. They need flushing early. If I had any question about whether one ought to be flushed, I'd ask the commission. And they would say, dismiss it. But that was the way a lot of that handled. And I don't think there's much way for you to draw up. I don't think, first of all, I don't want to sound like I agree with, I never have been able to pronounce his name, Mr. Dealer's 5-page letter. But the one thing I think you might, I think don't think I think the Supreme Court's got to do that. I think they're going to end up having to write the rules.
Oh, yeah.
And I don't think the legislature wants to try to do that, because if you do, you'll have a real difficult time.
We don't write rules for other agencies.
Yeah, I just think well, even if you had the authority, I don't think when you started doing it, I think you'd want to do it. We have, Jeff and I sat down at least on 2 or 3 occasions, trying to do a proposed revision of the rules to submit to the Supreme Court. And we kept saying, well, then they started talking about revising the canons. So, and we did do the revision of the canons. They went into effect this year. And now the next effort was going to be, I think, to rewrite the rules and get the Supreme Court to issue new rules. So we were going to suggest to them what they might be. But I guess they're going to wait now until they find out.
They're in the process, Judge, of doing rules as we speak.
Yeah.
Anything further, Ms. Hall?
Coming up with some rules.
Yes, sir. Mr. Powell? Give me a number at 19 or 18.
If somebody made a complaint and you determined that it was without basis and so you flushed it, as you say.
Well, I could use a different word. I mean, we dismissed it.
But if you at least send a letter to the judge saying that there has been this allegation or this complaint against you.
You could.
Did you do that?
I did if I thought it would help the judge. Also, but if you're not really careful, the judge can read that letter and he knows who it was. He knows exactly who you're talking about because he remembers that issue coming up.
But at some point in the process, the judge is going to find out that there has been a complaint or that there is an investigation or there is an inquiry. No?
No, not. He would never find out unless he did something like that again, and we wrote him a second time. You know. But,
so at what point in time does a judge ever become aware that there is?
He might not if it was dismissed for total lack of any substance.
I understand that. Yeah. But for those that are not dismissed for total lack of any substance.
Well, you get into that now where I write him a letter and ask him to explain.
Right.
Example, city court. We call it municipal court now. I'm getting my terms up. Municipal court judge, I go and sit down in his court. I got several people were calling the office about him, and I said, let me run over there. So I went over and sat down in his court, and I wrote him a list of, I wrote him a letter. I think it was 12 or 13 things. I said, can you explain to me why you do this? And do you know what he wrote me back? He sent me a copy of his resignation letter. That was the entire investigation, inquiry, investigation, discipline, whatever. I just went, looked, and said, can you explain this? And he sent me his resignation letter. And it was the right thing for him to do, too. I mean, it was one of those courts that you just say, whoa.
But assuming that it's not cut and dried like that, you write a judge a letter and you say, we've had this complaint and we'd like for you to tell your side of it.
Let me hear from you in writing. He'll usually, I give him a month to do that.
All right, so he responds and you're satisfied with his explanation. You know, there might be some things that could be done differently, but it does not arise to something that the commission ought to sanction somebody. Do you tell him that the case has been dismissed?
Yeah.
I mean, is that a routine practice?
Oh, yeah.
Is that part of the...
write a letter back and say that you can close your file, nothing, the commission voted not to do anything. Or
The reason I asked was that I had a judge that mentioned to me that somebody had made a complaint that he had not recused himself when they felt like that he should have, and that he was advised of the complaint and, you know, invited to give his version of events. And he did, and he never heard anything back from the commission. And he asked another judge, and they said, well, if you hadn't heard anything in 3 months, then they've probably dismissed it. They just don't tell you that. And I'm curious as to whether there is a formal process where you actually tell somebody, it's over, don't worry about it, or that it's going to be hanging over your head because nobody will tell you anything.
I can tell you that I tried to do that. I tried to do it as much as I'm not sure you may find one that I didn't do it in, but I certainly tried to do that because I was a judge and I know I'd want to know if it was over. I know of a judge right now that's been waiting for 6 months. He was told on the phone that it was okay, but he's been waiting 6 months for his letter saying, "Hey, that's okay. Don't worry about that."
So there's no real hard and fast rule that we let people know?
I don't know of a rule that says that. Jeff, did Jeff leave?
It,
you know?
It was just a policy that we had to always let judges know. When I was there, if we dismissed the case, I would write them immediately. I don't know what they're doing now.
I certainly tried to, and I did my best to, and because I was taking it from a perspective, but I'd want to know if it was me. Is that it's over. The other ones where you don't write are the ones that you don't ever tell them about because they don't really, the danger of them finding out and then acting ugly would be greater. And the judges that I knew, like I knew a judge from Tifton. I'll just leave it with that. I'm not gonna call his name, but and I wouldn't have sent him one because he's hot-headed and he might have flown hot the next time he saw that person. And I was doing it more to protect him from his own. He's pretty calm most of the time, but you could gouge him a little bit and get something out of him. But I would have wanted not to do it. Now, if it was a real complaint, he'd have got a copy, and I'd have told him what happened. But he didn't get a copy. But
other than the appearance of impartiality, do you think that there's a positive reason for having an adjudicatory panel that's separate from the investigatory panel because of the fact that they have not prejudged, already heard the stuff, and they get to hear it clean and fresh and can make their own decisions? Do you think that's the benefit?
Well, it's not only the benefit, it's more important than that. It's really important. We all know, and the lawyers who do insurance defense in here are famous for this, if any of you do. Juror comes in and says, well, I can't really be fair. And then the judge comes along and says, now you're not telling me, if I tell you to be fair and you tell you to lay aside your feelings and decide case based solely on the evidence presented in court here today, are you telling me you wouldn't do that? And they say, oh, I do that, Judge, I do that. Well, should that guy still be on? Now, I say that guy should not be on the jury. Should have never. Criminal cases are famous for that. I mean, you got I had a case one time, the sheriff's wife served on the jury that convicted my client. And I challenged it, went all the way to Supreme Court. Supreme Court said, that's okay. And but the panel is the same way. I'm telling you that to show you that the panel is, how do you say, I know I've been involved on the inquiry, I've been involved with the investigation, the charges now have been made, and I'm suddenly going to change my hat and become the jury. They're the fact finders. They're going to become the fair and impartial jury. How hard is it on them to do that? I don't think, not only is it just the appearance, I believe it's almost impossible to ask a human being to do that. In criminal cases, if a guy told me that he couldn't be fair, I stopped the voir dire and excused that juror and bring in the next juror. I didn't let them do rehab. I just stopped it. I didn't have to. The Supreme Court says I didn't have to, and I didn't. If you ever told me you couldn't be fair to either side, you were gone. And I didn't. I just cut out that rehab stuff. And I think we got fairer juries, no matter which way it cut. I did it, the knife cut both ways. I feel strongly, and I think you're asking too much of a panel to take the same 5 who hire and fire the director, who hire and fire the investigator, to then say, all right, now, I'm going to listen to you and be fair and impartial and give this other side just as fair treatment as they deserve. Well, it's somewhat the appearance of impropriety, but I think there's some actual impropriety in having a system that lets that happen. Just like letting that juror who just told you he couldn't be fair, letting him stay on that jury. Same.
Thank you, Judge.
Okay. Did I confuse anybody with that? I was rambling.
Very good. Anything further, Mr. Powell?
No, sir.
All right. Mr. Comer?
No, sir.
Mr. Kelly?
No, sir.
Well, I think we've probably concluded with you
I got out quicker
today,
than Jeff.
Judge.
Well, I will say this. I am interested enough in helping in this process.
Yes,
That if y'all run tight on money and you can't pay my mileage, I'll drive all the way. I'll drive all the way from Donaldsonville, Georgia, up here. If you need me to come help you.
We appreciate you coming too, Mr. Hyde. I want to ask you something, please, sir. And I'll excuse you, Judge. Thank you again for your service and appreciate your appearance today.
Appreciate you using the microphone.
Yes, sir.
One of my failings is I was sleeping too close to some 8-inch artillery in Vietnam.
Oh, really? Okay. I'm usually loud enough without one, frankly. Yeah. Would you mind today speaking to the committee on one issue today? And this is the question we've had circulating around about the Judge Scoggins matter. And I want you to focus on that, if you would. Have a seat and let you be sworn in.
Be glad to.
You solemnly swear that your testimony will be the truth, the whole truth, and
I do.
Let me say what I want to ask you about is I know you're
Well, that's a hard act to follow.
It is, yeah. I agree with that. But we want to have you come testify more about your time and experience with the JQC than just this one subject. But I thought while we're all today dealing with this issue and things that circulate around there, I think you were also involved with the Judge Scoggins matter.
I've been involved with all of these.
Yes, sir. And we're going to ask you about the others, but I want to get to Judge Scoggins alone as an issue today.
Yes, sir.
Tell us, what was your involvement with Judge Scoggins' issues?
I was directed by Jeff Davis to go up there. Jeff said there had a complaint had been made by Mr. Tate, and I was directed by Mr. Davis to go up there and inquire into what the nature of the complaint was. It had something to do with filing documents with the clerk of the court and also public access to the court. I went up to speak with the judge, and the judge was not in, but I did notice that the public was barred from attending court, and also court records were not made available to the public.
Court records not made available, how do you mean? If you wanted to see your record, you're saying?
While I was there, before I identified myself, I asked if I could look at some records, and I was told no.
Okay.
And I reported that back to Mr. Davis.
Was that one of the issues that was brought to your attention as by need to do an investigation, or what?
I believe it was. However, as a matter of routine, after doing these a while, one of the things in our checkoff list would be public access to the court and public access to records. So it would not be unusual, even if it were not the main complaint, for us to also look at public access to the records and to the courtroom itself. That was a very big initiative of the commission.
Okay. And you mentioned you were there. Was the judge there at that time you first visited? So you were dealing with who?
I was dealing with some, I assumed the clerk, but I don't know who it was.
Okay. Did you have any word as to what the complaint, the nature of the complaint, and who had filed the complaint?
I think, and you know, these cases run together to me, and I kind of purge them after the case is over. But I think I spoke to the judge that day on the phone, and the judge that day on the phone said to me, and I'm paraphrasing, "I knew this would happen. I know exactly what you're doing there." And I said, I don't know what you're talking about. And then he related to me what Mr. Tate had alleged to have done up there. And I called Jeff and said what the judge had just told me on the phone. And I think that was the last involvement I had in the case. Jeff shut my part of the case down.
Did you have any other visits to the court?
No.
That court?
No, sir.
Was it one time?
Yes, sir.
Okay.
Now, as far as I can remember, if you know otherwise,
I don't know for sure.
Refresh my memory, but I don't think so.
And in your conversation with the clerk, what did you mentioned at some point you agreed to open up the records. What brought that about? Did you tell her you were investigating?
I ultimately told her that I was with the Judicial Qualifications Commission. It was not a friendly exchange to begin with. I will say that they were not touchy-feely, nor was I.
All right, and Ms. Oliver. Yes, sir. Go ahead.
There's been something said earlier about the commission is refusing to give y'all records. I am here. I am the governor's appointee on the commission, and I'm speaking only for myself as the governor's appointee. I'm not refusing to give you folks anything about anything you need. You have access.
I understand.
I want you to understand I'm not voting.
We're going to go into that later. That's why I said I want to limit your testimony today just to this issue of the Judge Scoggins matter. Mr. Powell, anything you want to ask?
No, sir.
Mr. Comer, get your mic around if you would for me. It's working now, I think.
Great. Just to clarify, I think this can be inferred, but I want to get your comment on it affirmatively. You had no interaction with Mr. Tate with regard to the Bartow County Probate Court matter, is that correct?
That is not true.
Okay.
I think I did talk to Mr. Tate at some point about it, but I don't remember what he said.
Did you, when you talked to him, what was the purpose in talking to him?
I think he had called me to reiterate that there's a problem up here in Bartow County. At that point, I did not know that he had had words with the judge.
So that was before you went to Bartow?
It was either before or as I was getting there.
Okay. But you'd already been instructed by Mr. Davis to go to Bartow.
Correct.
When Mr. Tate called you to give you additional information about Bartow?
Correct.
And I said Bartow, I'm talking about the probate court in Bartow County.
Yes, sir.
And so did you have any follow-on conversation with Mr. Tate after you finished your interaction with the clerk in Bartow County Probate Court?
I think, and at that time I was the investigator, not a commissioner. I think we spoke about it at a commission meeting, and I think the case was ultimately dismissed at the director level, and I think the commission signed off on that.
Were you at the commission meeting when it was discussed?
Yes, I've been at all commission meetings.
And when it was discussed, was the issue of the allegation of Mr. Tate's interaction with the clerk addressed at that commission meeting?
I believe it was, but let me say this about Mr. Tate recused himself when that complaint came in. He did not act as a commission member during the pendency of that complaint.
Why?
That has always been our policy. If you're a judicial officer representative on the commission and the complaint is in your circuit, you recuse. If you are a trial lawyer and you have a case before a judge that we are investigating, you recuse. If you are a other person that makes the complaint on the judge, you are recused. For example, now we have a docket where there are several judges that I investigated that I'm now, as a commission member, I am recused from sitting on those cases. We do that. It's usually a self-recusal. I think in the history of the commission, and I've been there almost a decade, we've only had to use the involuntary recusal rule one time. And it was when a judge had it was a case where a judge had a judge before the commission from the same circuit.
And when the issue was addressed in the commission meeting, and I want to clarify what I'm talking about. I'm talking about the allegation that Mr. Tate had made some kind of comment about being a member of the JQC and using that as leverage to get some kind of action from the court. Was that discussed at the commission meeting?
An action from the commission.
When the issue of the alleged conduct by Mr. Tate,
Right.
was that conduct discussed at the commission meeting that you attended to discuss?
Not that I remember, no.
Okay. All right. Do you know whether any other member of the commission was ever told about the accusation that Mr. Tate had that interaction with the clerk in the Bartow probate court?
I think the entire commission was informed by Mr. Davis, and I was there.
So that was brought up at a commission meeting?
Yes. In a very Jeff Davisonian pastoral type way, though. It was. You've heard Jeff.
So what I hear you
diplomatic.
saying is it may have been brought to the attention, but it wasn't. It sounds like it wasn't brought up like, hey, we've got a problem that we've got to address with
That
this
is
commission
correct.
member. It was just, oh, by the way, everybody, we've got a commission member who may have done something inappropriate, but don't worry yourselves about it.
No, I don't think that happened at all, but I think Jeff said it and no member followed up on it. And as staff members, it was not our position to either interrupt a commission member when they're interviewing a judge at a meeting like with Becker, or come to a commission meeting and make all demands. I mean, as an investigator for the commission, I rarely spoke at the meetings. On the Becker recording, you may hear me say one thing. As staff members, we let the commission, that's their meeting. Jeff and I, or Judge Lane and I, would talk 20 times a day. So we looked at it as the commission's time to get together and talk.
And if you knew of some impropriety alleged against a JQC member, who would you go to?
Well, you'd have to define impropriety.
If you knew about a member of the JQC threatening a sitting judge with some action by the JQC if the judge didn't do what he wanted him to do, who would you report that to?
As the investigator or as a commission member?
As an investigator.
To the director.
Okay. And, all right, we've heard from the director.
Right.
So as a commission member, how would you deal with that?
I think that I would deal with it with a commission member in as diplomatically as I could. But that was an aberration. That doesn't happen.
Well, I understand, and of course we have the rules. The rules of conduct are for preventing the aberrations. I mean, most people are going to do right most of the time, but we have issues that come up in society when we have to deal with those outlying events, and this is one of those. I understand. So, as I hear what I hear you saying is, as a commission member, if there was an allegation of impropriety by another commission member relating to his or her position on the commission, the best recourse you have is to go to them and say, that's inappropriate.
No, that's not the best recourse. That is a recourse. So the other recourse could be to go to the appointing authority. The other recourse could be to go to the chairman of this committee, or to the speaker, or to the governor, or to the Atlanta Journal-Constitution. I mean, there are all kind of things you can do, but that's not the first thing you do.
Sure.
I don't run to Wendell Willard every time I think somebody's broken a rule.
And ultimately, Chairman Willard or any other member of the General Assembly at this point has no position of authority, no way to give guidance or oversight other than to occasionally review your budget. Is that correct?
I disagree with that totally. You folks represent 10 million Georgians. I mean, and I, as the governor's representative, kind of do that also. I think the commission is answerable to all of you, to the General Assembly and to the governor and everybody else.
And by what process is the JQC answerable to the General Assembly?
I think that every year we come into this room or a room like it and we have to justify the budget request, or Jeff, and it's not me, it's Jeff or the director.
Right, and so for some specific misconduct by a member of the JQC, the General Assembly does not have an oversight. It doesn't have a recourse for dealing with that at this
Other than
at the
impeachment,
current.
you're right.
Okay, thank you.
One other thing, Mr. Hyde, Are you aware that Judge Goggins ever made a request to come and appear before the JQC on this matter?
I'm aware because I've seen correspondence to indicate that.
And did he ever have that opportunity?
He has never been to a meeting.
No, that's my question. Was he given that
I
opportunity?
don't know that. That would not be my role to advise him of that opportunity. I was the investigator.
But he never has appeared
He's
before
never
it.
appeared, I can tell you that.
All right.
It would not have been my position to invite judges to the commission.
You say you've seen correspondence. Was that his correspondence to the commission asking for this ability?
I don't know. It's the correspondence I asked for to prepare for today that I looked at, and I don't remember if the correspondence was from the director to the judge or the judge.
This was in his file?
It was in the emails that I found on my computer.
On your computer, okay.
That you're welcome to.
Thank you. Yes, sir. Mr. Comer.
Mr. Chairman, just want to add, I do appreciate you being here today. I know you don't have to be here, and you're not under subpoena to be here. I appreciate your willingness to cooperate with this committee and the openness with which you've come here to testify today. You're to be commended for that. Thank you very much. I hope that you are an example to others.
Well, 30 seconds.
Yes, sir.
Justice Namias and myself and others, or Jeff Davis, the bar president, are working on fixing the rules that are going to address a lot of your concerns. But more importantly, Justice Namias and myself, when we met with the chairman a couple of weeks ago, we're going to propose in the next week or so a suggestion on House Bill 808 that will create by statute an independent hearing panel that I've been wanting a hearing panel for 10 years. And until now, nobody's listened. But Justice Namias and myself and others are working on that to suggest to you folks, and we've talked to the chairman about it. And I think that will alleviate a lot of people's concerns about the due process and the appearance of due process.
And I'll follow up saying, again, under the present structure of the constitutional provision on the JQC, there is no way to have that ability, and that's why we looked into having a constitutional amendment that does give a broader way of handling work done by the JQC in a more fair and due process manner.
Right.
Thank you, Mr. Hyde. We're going to adjourn as far as taking any testimony. Excuse me. There will be no further testimony today. I want to talk to the committee on a couple of matters. You have in your file a letter that is proposed for submitting by the committee, to Judge Patsy Porter, who is the current chair of the commission. I hope you've had a chance to look at that letter. The purpose of this letter is to first make a request by this committee to the JQC that will be hand-delivered to her, and contained with the letter will be the two releases that will be signed by Judge Goggins and by Judge Becker. And the letter is for the purpose of requesting that these files be given to us for our review as a part of our total study and investigation. Now, I want the committee to review the letter, and if this is something that you agree is an approach to be taken, we'll have the letter finalized, and I'll be signing on behalf of the committee. Is there any questions from any committee members regarding the letter? Is it agreeable by everyone that the letter be submitted to the commission through Ms. Porter as chairman?
Mr. Chairman, I agree. I might be a little bit more flexible on the 3 days, but I'll leave that to your discretion.
I understand, and if that's a problem, I can't imagine what the purpose of that is, because we're having the judges brought in with us next meeting. We expect to have Judge Becker and Judge Scoggins attend and testify before this committee next Thursday. And I was hoping to be able to have their information in hand prior to their testifying. It won't stop their testifying, but I think it would be beneficial if we had a chance to see the file as a part of their testifying. That's the reason I use the 3-day. Thank you for the question, though. Anything else? Then with your approval, we'll finalize the letter and hopefully have it prepared by tomorrow to be delivered to Judge Porter, excuse me. The other thing I want to talk about is Wayne Allen, who is our counsel through the Legislative Counsel's Office, also counsel for this committee, at my request, has done some review. This is based upon what we see to be potentially forming challenges to the validity of this committee as a part of the legislative branch of the House of Representatives to seek documents or individuals, if necessary, to appear before the committee. And Wayne, I'd like for you to address what your position is as far as your review of the law on this point. Let me get your own number. What, number 13?
13, Mr. Chairman.
Your own.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, I'll preface my remarks by saying that I actually started looking at this issue over a quarter century ago. A little class called Law of Legislative Government under a gentleman named Perry Centel. And I'm sure glad I saved my notes.
Professor Centel, yeah.
I think the clear weight of authority is that the inherent power of either individual house of a legislative body, state or federal, acting through a committee to investigate and issue subpoenas in aid of the legislative function and to enforce such subpoenas through contempt proceedings is clear and long established in American law and history. My counterparts, other legislative councils in other states, which are members of National Conference of State Legislatures, agree with me. More importantly than that, however, Mr. Chairman, I'll go right to the top, and that's the United States Supreme Court decision in the case of McGrain versus Daugherty back in 1927. In that very lengthy opinion, the court devoted 16 full pages in that report to examining this very issue, and it looked at both what has happened in the states and the federal level. And I'd like to briefly quote from an important part of that decision. Quote, in actual legislative practice, the power to secure needed information by such means, that is subpoenas, has long been treated as an attribute of the power to legislate. It was so regarded in the British Parliament and in the colonial legislatures before the American Revolution. And a like view has prevailed and been carried into effect in both houses of most state legislatures. The state courts quite generally have held that the power to legislate carries with it, by necessary implication, ample authority to obtain information needed in the rightful exercise of that power and to employ compulsory process for that purpose. I don't know how you get a clearer statement than that, Mr. Chairman. If I may continue.
Yes, sir.
There are many other authorities which review these legislative inherent powers. And I'll just briefly recite from some of those authorities the points they make. That the right to investigate any lawful matter is a right separate and distinct in each house of a state legislature, and that power may be exercised through a committee of either house. The state legislature may proceed to make any investigation within its authority by authorized committees of one or both houses. The houses can act jointly in appointing a committee, or either house can act alone. And indeed, in history, the Georgia House of Representatives has acted through a single-chamber House-only committee to investigate departments of state government. And since a committee acts on behalf of its parent house, which is how the legislature functions, under its authorization, as this committee is doing here on H.R. 1363, a subpoena issued by a committee is treated as if issued by the parent house itself. Furthermore, there's been some issue of separation of powers, that this body could not investigate another branch of state government. The Georgia Supreme Court has squarely held that that is not so. The Georgia Constitution's provision for separation of powers, and I quote, does not prohibit a person in the legislative branch of government from investigating the official conduct of any person performing duties in any branch of state government. That's Dean versus Bolton in 1975. Now, as far as the relationship between the inherent powers of the General Assembly and its statutory powers, yes, it is true that Georgia, as with some other states, has additionally provided statutorily for such powers and procedures. But those statutory powers, as the authorities recognize, are not in lieu of the inherent power. They are in aid of, in addition to, the unquestioned right of the General Assembly. So this body, in exercising its power to investigate, may rely upon either its inherent powers or its statutory powers. And that grant of power is to each house thereof, acting independently of the other, due not only to the way the inherent power is interpreted, but also to the Georgia Constitution's provision for an independent existence and powers of the House and Senate separately. The Constitution provides for a General Assembly consisting of a Senate and House vested with legislative powers. Working back to the McGrain decision, U.S. Supreme Court, which recognized that while bills can become law only after being considered and passed by both houses, each house is distinct from the other and has its own officers and rules and exercises its legislative function independently. Those legislative functions include investigating and issuing subpoenas. Interesting point here, as the witness Davis referred to the fact that the Georgia Supreme Court, by the Georgia Constitution, has the authority to adopt rules. It is pursuant to those rules that the JQC issues subpoenas. I note further that the Georgia Constitution provides that the House and the Senate separately provide rules for their own governance. Those rules provide that subpoenas are issued on behalf of the House at the signature of the Speaker. Subpoenas are issued on behalf of the Senate by a signature of the President of the Senate. They provide for separately issued independence without the need of the other body acting jointly. Finally, the question has been raised about the timing of this investigation. As a matter of law, Mr. Chairman, that's irrelevant. The General Assembly is free to legislate at any session it wants to regarding the JQC or any other department of state government. And in fact, the resolution which created this committee provides for the committee to report back to the General Assembly with its findings and recommendations, and those recommendations may include proposed legislation. And as the committee has already discussed, there's a possibility of tweaking some of the implementing legislation in the 2017 session. And if I may, I'll close with one more important quote from a U.S. Supreme Court decision. This is the case of Watkins versus United States in 1957. And I quote, "It is unquestionably the duty of all citizens to cooperate with the legislative branch in its efforts to obtain the facts needed for intelligent legislative action. It is their unremitting obligation to respond to subpoenas, to respect the dignity of the legislature and its committees, and to testify fully with respect to matters within the province of proper investigation."
All right, thank you. Any questions of Mr. Allen by committee members? Appreciate your report. Let me give you briefly for the committee and the public. Next week, as I mentioned, we anticipate that Judge Scoggins and Judge Becker will be here. We hope that we have their files, but if not, they will still be present. If the committee so wishes, I felt that the week after that, we would invite any currently sitting members of the JQC to appear before the committee and at that time testify on the issues of addressing the work of this committee. Would that be acceptable to committee members? Then we will stand adjourned at this time unless there's any other business. Pardon me? We don't need to vote. Okay. It's agreed to.
Chairman Willard, I would like to ask, when are you going to allow for citizens who have had to deal with JQC in the past? When are we going to speak?
We'll probably look at doing something after we complete the line of questions I mentioned as far as the anticipated next two meetings are lined up, so it may be sometime, if this is now the early part of September, it may be the latter part of September.
Okay, thank you for answering.
All right. We'll stand adjourned. Thank you all for your time and attendance today.